Okay, guys, so this is the murder trial of the only fans model that murdered her boyfriend. And before that, we seen the footage of her assaulting him inside of the elevator. So let's just get straight to it.
Wait, where is Sean and Mr. Quentin? Quentin. Hey, babe. How you doing? I'm okay. So who's coming? Who's coming in January? Who's coming? She's here already. No, not yet. I don't know yet. I don't know. But I heard there's gonna be some changes. What's the club before? Yes, sir. Can I have your name?
Okay, guys, this footage was really grainy. I don't know why, but it kind of has some like glitches and things going on with it. So bear with it. It's not me. I'll refresh if needed, but I mean, it's the best I can do. Well, that they can do.
Mr. Quinn, good afternoon. You have anything for me? You have anything for me, honey?
I have a lot of stuff for you.
A lot.
No, just on the process. You doing okay?
Yeah.
How's everything?
I'm waiting to see what you got for me.
It's all in the process.
Oh, it's a flash drive. Great. Perfect.
Come here. So this is our everything is on here. I was gonna have a copy for you. You see, I'm good. I know, but I'm good, sir.
So all of this is on here.
I'm
Yes.
getting all the names.
Thank you. All right. That'll work.
No, they're coming. Could you imagine? I mean, I can.
I know you're the best, man.
Hey, I gotta buy you a drink now.
Don't buy him nothing. Have you have an extra thing to take? Is that on here? You want me to do this as a composite or just one? Of course you can. So this gonna be Sean. 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 Sean, so you know, the flash drive is 1 That's the only one. The next is yes.
No, I see. Choose another.
Everybody who's still on Zoom, just a reminder for those of you who are on Zoom, please remain muted so that we can hear what's happening and move forward. If you're not muted, then I will go ahead and mute on your next. Everybody speaking.
Yes, Judge. And for the record, Sean Abduhoff, Khalil Quinnen, and Kathleen Hogue on behalf of the state.
Good afternoon, Your Honor. Larry Hanford on behalf of the Obumseli family representing the victim.
Good afternoon, Judge. Frank Diaz on behalf of Courtney Clenney, as well as my co-counsel Sabrina Puglisi.
Welcome, everybody. And I know that there are probably family members who are out in the audience as well. So I know that this is probably an emotional day for everybody. A reminder that if you feel the need to step out, that's absolutely fine. If you need anything from my bailiff, his name is Ollie, he can help you. Reminder to just remain respectful and courteous and quiet. So let's go ahead and get started. For the purposes
First and foremost, first and foremost, the defendant's argument to preclude the state from using the recorded statements, frankly, for the purposes of this setting at least, is untimely. It is a substantive motion as outlined by the case law. It requires competent substantial evidence for which the burden's on the defendant. Before the court, there isn't any, not even an affidavit to submit to the court. So the defendant would be unable to support its burden under the case law to meet the two-pronged test that I outlined previously to the court. Furthermore, as it pertains to that issue, there are 4 videos. I'm just going to mention the videos because I don't have them off the top of my head. I have to stop my argument to go mention them. The first video is in the lobby of a building in public, clear as day. I mean, the defense can't even on its face make an argument for that, assuming that they somehow meet the two-pronged test. The second aspect as it pertains to the three following recordings, frankly, the defense is counters their point. It is a recording by security from the outside of the building.
Really quickly, when we saw these right there, or that I watched, I didn't see a video portion to any of them under
Number 1.
my computer, just played the audio.
Um,
So again, it's available, but I was able to bypass it this time for the audio, so I couldn't see a video. We were sending it from the audio.
Sure. Again, I can. That one is, and council can agree with me or agree with me. It's my recommendation. The lobby of the building. It shows Miss Clenney with a dog walking up and sitting down. Mr. Obumseli is reporting the camera facing up. For a while, it reports Miss Clenney's chest, and they have a conversation between them. And Miss Clenney or Mr. Obumseli says something to the effect that it's not right to pick me, and she then whispers in response some expletives. That all happened in the lobby of the building. There's no expectation of privacy there, period, bar none. So the defense would be impossible for the defense to show an expectation of privacy as it pertains to that. The 3 remaining ones, I would agree that they occurred in their apartment. Very brief snippets. You can see the apartment from the inside, either the TV or the clothing on the floor or something to that effect. So I don't disagree with that. And assuming the defense is able to make their showing of two-pronged test, they would fail on the reasonable expectation of privacy. Explicitly, actually, their defense exhibit G, which while they characterize it as, quote, audio surveillance, I have for the court the incident report from the building that day, February 26, 2022, where the security guard said she recorded the woman's voice. It's the last sentence on that. So it's a recording from the outside of the apartment. So certainly a recording from the outside of the apartment is different than a recording from the inside of the apartment. But the point is that if it's audible from the outside of the apartment, she does not have a reasonable expectation of privacy. And the very nature of her shouting and the building sending her emails about the arguments, police responding on calls by her or anybody else because of the arguments, necessarily relates that a reasonable person shouting at the top of their lungs can expect that their neighbors will hear it and possibly record it. The fact that Christian recorded it is of no consequence. Whether she consented to it is of no consequence because 3, 5, if I'm not mistaken, it's items 3, 5, and 7, because I believe the videos are odd numbers and the metadata are the even numbers on exhibit 11.
Judge, with respect to the lobby video, we don't have an objection to that. But it's clear that there is no video. Your Honor is correct. There's no video on those other recordings because the recording device, which is the phone, is secreted on his person. So that's why there is no video, because it's on his person. With respect to the state's argument about the security could hear outside, that's a separate incident. That is not the day of these recordings. And this apartment, and this actually is important later on in our presentation. This apartment had an elevator that goes directly into the apartment. It's got basically its own floor, own entrance. This is not an apartment building that has multiple units separated by thin drywall. Okay, this apartment had its own floor, and the state cannot dispute that. The state also cannot dispute that this was a surreptitious recording, secretive on his person. Therefore, it's a clear violation of 934. It's an illegal wiretap. This is a two-party state. And the only thing the defense has to show is that there's an expectation of privacy and that society is willing to accept that. And that's in Canario, I think it's in Canario, I can't pronounce it, in Serrano, State versus Serrano, which is 473 Southern 2nd, 1272. And that is a Supreme Court case from 85. That case talks about, is there a reasonable expectation of privacy for the oral communication, which clearly it's an oral communication, and whether or not society is willing to accept it. What more would society be willing to accept than somebody, whether they're raising their voice, yelling, screaming, than their own apartment? That is clearly, we've met the burden and the standards that is elicited or is laid out in State versus Incarnati. Further, Judge, the recording, the big difference between the recording that the defense submitted to you with, I think it was G, is a recording by a security guard from the One Paraiso building. Pursuant to her job duties, she is investigating a disturbance. Anything she records during her duties is something that it would be, number one, it's not going to be hearsay because it would be a business record, right? Kept in the regular course of business. And so, I mean, again, hearsay could be admissible in this type of hearing, so I won't even address that. But what is different is that was a call to security for a disturbance. Normally, there would not be anybody outside her door. There wouldn't be. So the reasonable expectation of privacy that Ms. Clenney had is obvious. And I think it's an expectation of privacy that society is clearly willing to accept in one's own apartment under the circumstances of this particular case.
So let me say this, first of all, I'm going to deny your request for not having this as a hearing because it's untimely. We want to go ahead and allow our reports so that I can make a ruling as to whether or not these recordings are going to be in evidence for the purposes of the Department hearing only. I think that you can make arguments both ways as to both the defense's allegations as well as the state. So I'm going to go ahead and hear arguments and make a ruling on it. Second, the recording that is taken by the security officer at the apartment building, are you both agreeing that that is a recording of the same incident that is being played under?
No, that was February 26th, Judge. Again, it took a little digging because it was resaved as a different thing, so I didn't know what it was in reference to. Once I located it, I located the adjoining report, which again I have for counsel and for the court. And so it is not the same incident, but again, the premise of that argument, and frankly, the fact that it's audible from the outside at this point, we can agree that it is not inaudible. We can hear Miss Clenney screaming.
And was that also taken from the inside of your apartment building?
So that distinction doesn't matter, Judge, because if it can be heard outside, it doesn't matter if Miss Clenney is expecting someone to be outside her apartment or not.
That's not my point. My point was that were they inside the apartment when that?
Yes.
So it could be heard outside the apartment.
Yes. So the defense exhibit G is an audio recording from the outside of the apartment. It actually illustrates the state's point as to why Ms. Clenney would not have a reasonable expectation of privacy in audio sound waves that are beyond the reaches of her apartment. The detective can testify if necessary, but there were complaints from individuals 2 floors above and 2 floors below. So irrespective of the private floor, quote unquote, there were 3 months worth of Miss Clenney screaming. And again, just as a reasonable matter, an individual does not have an expectation of privacy in their sound waves being too far and too loud for other people to hear. And again, it's audible that she is screaming in the video.
Judge, just as a final matter, the way this building is laid out, and if necessary, I'm sure the detective can testify to this, and all callers and witnesses. The only people that can access that apartment and the landing area outside of the elevator is with a key fob type thing that has to be inserted into the control panel of the elevator. That's it, that or an employee. So a reasonable person would know that nobody's coming to my foyer landing area outside the elevator. It's a disingenuous argument. It was a very private apartment complex.
I think that is true, generally speaking, and I think for the conversations that are recorded where she's not yelling at the top of her lungs. In fact, I had to turn it down when I was listening to the lowest point of my volume on my computer because she was yelling that loudly. I think that your point is belied by the fact that these conversations had occurred previously in her apartment and had been disturbances that neighbors had called in. If they had not been able to hear her and if they had not been able to hear her from other apartment buildings, and they would have been called in, number one. And number two, the fact that happened in February, so it's on notice of the fact that everybody can hear her screaming. They've already called security on her, they've already called police on her.
Well, Judge, I think they called the police on them, to be clear.
And that's true. And I'm not disputing the fact that there's an argument going on, but I think that also belies, at least with that video. I agree with you, the ones that she's not screaming, I think that she does have an expectation of privacy there, but she's talking in normal voice. But the one where she's screaming at the top of her lungs, for the purposes of this hearing only, I'm going to rule that I'm going to allow it in, because I don't think that there is that subjective expectation of privacy, number one, and number two, I don't think that it's one that society would reasonably accept for the purposes of this. And again, it's just for this hearing, we can readdress this at a later time. We're going to allow a recording of the lobby, because it's in public space. The ones where she's not going into me, I wrote down, I think, videos 1 and 2. The ones where she's not going and that she is in her bedroom, I'm going to exclude, because I think that she does have an expectation of privacy.
So I have them listed, judges, items 1, 3, 5, and 7. Items 1 is in the lobby.
So I think 3 is not yelling, 5 and 7 are yelling.
So with regards to that, Judge, she actually is elevating her voice.
Okay, they're the only ones, I mean, I made a distinction, and that's what
That's
my
fine.
ruling was gonna be. I mean, when I have to turn my volume all the way down because the voices are that raised, I can see that there's a distinction potentially there. That's what I see. And the second video, which is not the lobby, I did not hear the raised voices.
So then for the purposes of the record and the clerk, item in Exhibit 11, the court is admitting item 1 and 5, item 3 and 7 are not considered. The metadata of that obviously should be admitted just because of content. But so items 3 and 7 are not admitted.
I'm sorry, I thought she said 5 and 7.
I think the 7 was a continuation of.
Oh, okay, sure, okay.
I mean, if I'm.
Okay, so it's just 3, I'm sorry. I misunderstood.
So next up for us, I think I have defense's motion to strike state's motion to keep on. So, yes, Mr. Greco, you can go ahead and give your argument as to that, but your motion as well as state's response.
Sure, Judge, our motion was very detailed. I think that we can rely upon that with much argument. I would just say, obviously, we've been scheduling this for quite some time, Judge. And at no time did the government file their motion for pretrial detention, right? It says the plain language of the rule and the accompanying statutes indicates that this is close to first appearance, but then they latch onto the at any time before trial. But we've been putting the court and the state on notice of this hearing. And clearly it's an attempt to undercut the extremely high standard of Arthur, proof evident presumption rate. And we think that based on the delay in the state filing this, the delay in not only the arrest of Ms. Clenney, but the delay then in filing this is grounds for the court to strike.
Judge, I had a motion for pretrial detention ready when she was still in Hawaii. We decided not to because it would require us to put on evidence within 5 days, and it was done as a courtesy. The case law is clear. The defendant has not been granted any bail, where it would be proper is almost first appearance, but for the fact that it's obviously not just been in custody, but it's still a setting where a bail would be addressed. Notwithstanding that, the defendant's argument would lead subsection B of the pretrial detention rule superfluous. So it would basically make it so that that whole rule has no purpose if we're not filing it, at a later stage.
So I do agree with the state when you are reading Rule 3.32, the plain nature of the statute does say that they can file within time. I do believe that the case law that defense provided is distinguishable because there has been no onset in this. It's not a motion to modify or vote on. It's a motion to no onset. Anyone to deny the defense's motion? Strike. Let's go ahead then and get to the substance of the arbitrary and negotiable pretrial detention. I'm assuming that you want to hear both together, but you guys can let me know if you have other ideas about that.
For judicial economy, I believe both are appropriate.
We're fine with that, right? Before we start, there's one objection we have, and it's to the state calling witnesses in this case. If you'll recall last week in our hearing on the 8th, the state asked if we had any witnesses to call. We talked about Miss Clenney, the mother, and I said, Judge, vice versa, we would like to know if the state has any witnesses or exhibits so that we can prepare. We heard nothing from them. In fact, still, as of yesterday, when we filed our response, in the response, it actually says regarding the medical examiner, there's been no report or even a witness list advising he's going to testify. Yet this morning, we just were told a few minutes ago, not this morning, like here at the hearing, right before you came in, they're calling the detective and the medical examiner. We've not had any opportunity to prepare. They did not advise us of this. We just want to make sure the court is aware of that.
Yes, Judge. So both two witnesses, our lead detective as well as the medical examiner, have been listed in discovery. We have a right to call any of these witnesses, any of the listed witnesses in our initial discovery witness list. The medical report, our medical examiner's report, was made available for copy inspection. That's not something we turn over. They have to request it through and then pay the fee to the medical examiner's office. So the fact that they had not done that, they were advised of how to do that, that's on them. That's not us. And so we're calling those two witnesses. They know who they are. Just because they're not prepared based off of, for whatever reason that they're saying, we made them available with this information ahead of time.
Judge, for whatever reason, is that they failed to advise us after Your Honor actually said, I believe at the hearing, you said, yes, everybody please exchange what witnesses you're calling. So I'm not saying that we weren't aware. Obviously, we're aware of these individuals. We have reports. That's really not the point here.
I think that as long as witnesses have been listed, then we're certainly on notice of those witnesses that can be called for the ARPA hearing, particularly in an ARPA hearing. Depositions haven't happened, discovery hasn't happened. It's very close to the beginning of discovery also. We are dealing with a portion of this case that is at the very beginning. So I'm going to allow them to call their witnesses as long as those witnesses have been listed in discovery, which they have. He's correct about the NH report that it has to be requested independently. So let's go ahead and begin. Okay, but your objections have it.
Thank you, Judge. Judge, could we have some type of ruling from the court that in any future evidentiary hearings that the state will properly and timely disclose witnesses?
Well, I think that discovery only requires that they provide those witnesses as a witness list or any A witnesses that they believe might be used at trial. So I don't know that they have any other discovery obligations than that.
I guess it's just more of following the court's order, which your order was.
And I think that my order would have been, and then maybe I misspoke, is that any witness list have to be listed. As long as they have listed a witness list, and you have listed a witness list, you know, discovery obligation witness list, then I think that everybody has discovery obligations.
And Judge, because you mentioned it, I have to know the defense has not made any discovery exhibit list, but we are not raising that as an issue.
Okay. All right, so let's go ahead and get started.
Is this okay? I mean, it's a little crowded over here, but.
All cell phones will be turned off. Step out. And you step out.
It's me, Your Honor, I'm sorry. I'm sorry, I apologize.
All right, I don't think that there's any place else that we should check out.
I'm sorry. I'm sorry to everybody that my back. This is the court making it. Your Honor, today we're at the court does our pre-trial detention and incarceration setting at this setting. As the court is well aware, there's certain different burdens of proof. It is a joint hearing. I'm outlining here on the screen right now the proof of pre-trial detention. Our burden is only to show the defendant is charged with a dangerous crime. Dangerous crimes include both homicide and manslaughter. I'm only noting manslaughter because the defense has raised a possible lesser quote-unquote offense of manslaughter. So if they're conceding manslaughter, they're just conceding this ground. But the point is homicide, which includes manslaughter, are both dangerous crimes. The state's burden has shown that there is a substantial probability that the defendant committed the offense. The factual circumstances of the crime indicate a disregard for the safety of the community. Obviously, the homicide kind of illustrates that. There are no conditions of release pursuant to Florida Statute 907.041 that can ensure both the safety of the community and her presence in the future. This is analogous to the standards of Arthur, but the distinction between the two are twofold. One is the state's burden is greater. The state has to prove the defendant's guilt with evidence or the presumption greater. However, this is counterbalanced by the weight of the evidence, the light of the evidence. Where in a pretrial detention setting, the evidence is not viewed as material to the state. In an Arthur hearing setting, it is. So all evidence is viewed as light material to the state. Conclusions, the inferences, they are all drawn as light material to the state. And I'm not, just mentioning that, as an inference, that is a direct quote from Arthur. It is a preposition that is set in the foundation of Arthur. As to the admissibility of evidence in both settings, hearsay is admissible, affidavits are admissible, as the court correctly noted. This is a proceeding that occurs early on in the discovery process. Availability of witnesses, compilation of evidence, much of it is reviewed, but not necessarily processed or by an individual that can theoretically testify to that as an expert. And I mentioned examples where a medical examiner doesn't testify, the state just admits medical examiners report, for example. So the state has entered into evidence 32 exhibits that the court has had an opportunity to review. I'm not going to review all of them at this stage, and Detective Christino and Dr. Hutchins will testify to much of the substance of evidence, but I do want to highlight to the court the date of incident. Much about this case, both from the state and the defense, will be similar fact evidence, but the date of incident is the crux of the situation. Mr. Obumseli was killed by a stab wound to the subclavian artery. He bled out as a result of that stab. Incidents from before can certainly cloud or create a perception of what led to it. And the dynamics of that certainly are at play, as the state is outlining in its motion. We're not avoiding that at all. But the date of incident, the circumstances under which the defendant killed Mr. Obumseli are particularly important. We extracted Mr. Obumseli's phone, and the day became just woke up home. That was at 10 a.m. Christian's in their living room, you can see it in the background, and they're just singing, lip syncing. The defendant is
Hey, yo, maybe dancing like Austin. Just get the fuck away. Yeah. Hey. Yeah.
Disable note in this video, the court can see the defendant's legs, and for example, the bruising that was photographed several days later and the defense will introduce on its own already exists. Christian is very clearly alive. So those bruisings could not have been created in the quote-unquote struggle of the defendant's characterized it where he was standing. It's just black. They existed before. And the court, through the other evidence, can compare the bruising, including the photographs that the state submitted to it of the defendant on the data. But what matters is the incident. Christian leaves the apartment at 3:55. This is the state's exhibit at the bottom, 14, channel 9. 3:55. He's on the phone. And by that I mean you'll see in the surveillance video, the court can see him holding his phone, not on the phone. He's walking his dog. The defendant called Christian repeated, almost at a frantic call. For the record, the times are 19:55, but that's in universal coordinated time, so this is local time 3:55. She called him 3 times in quick succession. Twice he did not answer, and then once was for a 40-second call. 10 minutes later, the defendant gets on Instagram Live. And on Instagram Live, she has marks on her shoulders. She has bruises. And again, we have not avoided the fact that this was a mutually abusive relationship. The issue is whether the defendant's conduct in stabbing and killing Christian is justified. So the bruising, the defense is going to try to suggest was as a result of a struggle that do not exist. So Mr. Obumseli returns at 4:32 and 44 seconds. He enters the apartment or exits their walkway, 22nd floor, at 4:33, which is at the exact same time the defendant is called Christian. It's a 13-second call. And then 10 minutes later, the defendant calls her mother. I redacted her phone number. Those were 2 calls at 4:43 and 4:49. And we know that the incident occurred in the first call because Mrs. Clenney admits it. So fewer than 10 minutes after Christian walks into the apartment, it goes from a simple walk, relatively calm, to him being stabbed. And the state notes that in Mrs. Clenney's statement, all Mrs. Clenney suggests is that she heard the defendant yelling that Christian was lying and for him to get out. And the state notes he was entitled to be there as a resident of that apartment. The defendant had no right to kick him out. But the simple fact is the defendant is making affirmative accusations. The defendant is making the attacks on Christian. The defendant waited 10 minutes to call, or excuse me, 10 minutes later, the defendant called the building security. 18-second call. And then 4 minutes after that, she called them. Like a portion of the 911 call.
And this is the key. You need to stop screwing up the heart and give me the airline. You go back into my arms. Ma'am, what is the address? Ma'am, there's a hospital nurse. This is a hospital or a business.
apologize. Police arrived within 5 minutes. I'm not going to air here. Stage exhibit 21 still shot. It shows the defendant's grave name, Mr. Obumseli's body. The defendant is transported to Miami Police Headquarters and interviewed, and she gives herself a statement. It's inconsistent throughout. It conflates the dates as a whole. It suggests that Christian had gone to Subway and that this incident occurred as a result of the Subway. We know from the key fob record, we know from the video, he was not returning from Subway. This argument happened earlier today. And it very might well have happened as the defense suggested, but she's conflating both of them to justify self-defense.
I don't want to be that way. I don't know. I really don't know. It's just the way.
She says, because I know I was afraid. Just for the record. That's it. What's very important is actually the arch of this statement. Is when Ms. Clenney was discussing how she got up after they were arguing over the phone, went to the kitchen, grabbed the knife. She paused. She stopped. She sat in her thought. The detective interrupted and asked her some questions, but she had to get out. She did not know whether this was justified at all. Based on the totality of the evidence, based on the medical examiner's testimony, the court will see that it was not justified at all. The defendant's statement is not correct. She could not have thrown a knife that would have landed at an angle, punctured 3 inches deep, and not lacerated, for example, Mr. Obumseli. That was physically impossible. Had she thrown the knife and it entered at a downward angle, she would have had to be above it, which of course she was not. No, the defendant stabbed Mr. Obumseli. It punctured his body 3 1/4 inches, and it pierced his subclavian artery. The court has those medical examiner evidence and reviewed it, and you can see the guide at a downward to his right, a person looking at the left angle. She stabbed him cross body. And the state agrees with his claim that this was not justified. And for those reasons, the state will ask the court hold.
I'll just sort of sense what will happen.
State calls detectives, you know.
Do you solemnly swear or affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
I do.
Good afternoon, Detective. Can you please introduce yourself to the board?
Detective Yermain Brasino.
Detective, what do you do?
I am assigned to the homicide unit.
And how long have you done that?
A little over a year.
Before that, do you have any law enforcement experience?
Yes.
Can you please tell the court your law enforcement experience?
I've been an officer in the city of Miami for about 9 years, 4 of which I was a detective in the robbery unit, and 1 now currently in homicide.
Do you know a person by the name of Courtney Clenney?
Yes.
Do you see Ms. Clenney in the courtroom today? Okay. Let's talk about how you came to know Ms. Clenney. And specifically, I want to focus you on April 3rd, 2022. Is that the date that you met Ms. Clenney?
Yes.
Did you know her from beforehand?
No.
Having discussed the April 3rd, 2022 day, let's walk through it. Under what context did you first meet Ms. Clenney?
It was at her apartment, just outside. She was detained at the moment.
And let's kind of walk through that. Why did you end up responding to her apartment that day?
I was notified that there was a stabbing and the victim had been taken to rider trauma and succumbed to his injuries.
So at the time that you met her, you already knew Mr. Obumseli was passed?
Yes.
So let's pierce this out. First, you met her at her apartment. Where's her apartment?
Her apartment is at 3131 Northeast 7th Avenue.
Is that Miami-Dade County?
Yes.
So you mentioned you were notified because he had succumbed to his injury. Obviously, that you're a homicide detective. That's how you got involved.
Yes.
And why is it that you're the lead detective?
It was just my turn to take the next case.
So just as a premise, you didn't ask for the case. It was just
Correct.
Okay. So you responded to the scene of the homicide. You met Ms. Clenney. What did you do?
Say that again.
What did you do?
We responded to the scene. We began to check the apartment and get in contact with the crime scene. And simultaneously, we had Ms. Clenney transported to the station.
Before we get into what happened at the station with Ms. Clenney, let's discuss the events of the day. Do you know approximately what time police was called out to the apartment?
I don't recall.
Okay. Would anything refresh your recollection?
No, not right now.
Okay. So you're aware that at some point police got called out to the apartment?
Yes.
You've reviewed the evidence, the body cameras, all the evidence in this case?
Correct.
Okay. So what happened when police officers arrived to the scene?
When police officers arrived, they were able to make contact inside the apartment. They saw Ms. Clenney cradling the victim. They were able to separate the two of them, provide aid to the victim while they waited for fire rescue to show up on scene.
And then what happened after fire rescue showed up on scene?
They were able to transport him to Jackson.
And do you remember approximately when Mr. Obumseli was pronounced deceased?
I would have to go back to my notes.
You can refer to the report. Let me know when your memories are fresh.
At 5:55 p.m.
So 5:55 p.m., he's pronounced deceased. You are dispatched as a homicide detective. We already mentioned how you responded to the scene, initial check of the crime scene, contact with the crime scene, and sent the defendant over to the police department. So far as everything, I guess, per protocol?
Yes.
Okay. When the defendant arrives to the police department, at some point you end up interviewing her.
Yes,
Okay. Now, just for context, did you read her Miranda rights?
I did.
Did she waive her Miranda rights?
Yes,
Was that audio and video be recorded?
yes.
Okay. And I'm directing the court to the recorded statement. So I'm not going to belabor the point. The court has reviewed the recorded statement. Would you synopsize the defendant's statement for the court?
So she told me that she was at the apartment. The victim had went down to go to Subways. When he went to Subways, they began to message each other, and through text messages, they got into an argument over sharing each other's location. He then decides to come back to the apartment. Shortly after he comes back to the apartment, another argument ensues. At that point, the defendant says that the victim grabbed her by the neck, slammed her against the wall. She was able to break free. Then she was gonna call her mother, and he didn't want that to happen, so he grabbed her and put her onto the ground. She wasn't able to explain how exactly that happened. After that, she was able to break free once again, at which point she goes to the kitchen. She grabs on a knife, and then she states that the victim ran towards her, and that's when she flung the knife or threw it, and it hit him in the shoulder.
What did anything besides that? Did Ms. Clenney say anything besides that in addition of substance, I guess, regarding this incident?
No.
So regarding the injuries,
Yes.
in this circumstance,
Yes.
I want you to tell the court, I guess, how you're evaluating the case. You know, where are you in your analysis of the facts thus far?
At that point, we were looking at it as a self-defense at first, but then later on, things started revealing that it wasn't what we thought.
So let's talk about that. So at the point in which you finish interviewing her, despite some of the inconsistencies in the statement, you are evaluating the case for a possible self-defense claim.
Correct.
Is that one of the reasons why you document how she looks in her injuries?
Yes.
Okay, so let's parse through that. Did you have crime scene take photographs of her?
Yes.
I'll direct the court just as general reference to the crime scene photos. Were there bruisings on her?
Yes.
Okay, will you tell the court where there was bruising?
She had some bruising over on her legs. She had some small bruising to her arms, and that was about it.
Okay. Do you have experience in seeing fresh bruises versus old bruises?
Yes.
Okay. Have you, in this context, right? Just as a human, have you seen bruises?
Objection, Judge, lack of disability, lack of predicate evidence, which are opinions. Judge, I believe that the state intends to try to elicit some kind of expert testimony from the detective regarding bruising. That's clearly the purview of an expert. And this, as far as we know, this detective has no medical training. He's not a doctor. He's a detective. So I object to him making any opinions as to when bruises were formed.
So there's a lot of parsing to that, and he's not issuing an opinion as to when a bruise was formed. He's issuing an opinion as to whether it's a new bruise or an old bruise. As human beings, we know what bruises look like in an older bruise versus a newer bruise. An older bruise is darker versus a newer bruise, which is lighter and coming into
I'll
color.
object to the counsel testifying as well, Judge. He's not an expert either.
Judge, can we approach sidebar very briefly? Judge, just as a separate preliminary matter, I believe the evidence was accepted by the court, and if it hasn't, I'm just moving all of the state's exhibits into evidence.
No, other than it was previously noted, so.
And I'll just refer to them as their sub-exhibits, and I believe in evidence there's state's exhibit 1 or 1A. Continuing the second, did you see bruising?
Yes.
Okay. And that bruising you said you mentioned it was on the arms and the legs.
Yes.
Did you see any bruising on her neck?
No.
Did you see any hand marks on her neck?
No.
Did you see any bruising coming in from her neck?
No.
Did you see any bruising consistent with her having been grabbed by the neck?
No.
Did you document the area of her neck?
Yes.
And are those, in, I guess, the photographs that were documented by forensic?
Correct.
You had an opportunity to review Mr. Obumseli's cell phone extraction.
Yes.
As part of that extraction, did you see videos from the same day but earlier before the murder?
Yes.
Okay. In those videos, did you see bruises on Miss Clenney?
Yes.
You also had an opportunity to review the Instagram Live video that she posted between Mr. Obumseli leaving the apartment and returning.
Yes.
Did you had that opportunity to review that video?
Yes.
And in that video, did you see the bruising on her?
Yes.
Now let's speak specifically. Let's speak specifically about those bruises, right? Let's separate arms versus legs. The bruising on her arms, were you able to see them in the Instagram Live video?
Yes.
And again, that video was posted before this murder occurred.
Correct.
So those bruises were before the murder occurred.
Yes.
Let's talk about the legs. You saw bruising on her legs in the earlier posted video of her death.
Yes.
In that video, are those the same bruises you saw later that day?
Yes.
So, and then the metadata of those videos were like 10, 11 in the morning same day.
Yes.
So let's continue through this. You mentioned that Miss Clenney told you and showed you how she threw the knife or flung, as you said, at Mr. Obumseli.
Yes.
Would you please recreate to the or reenact to the court the manner in which she claimed she threw this knife?
She said she put it over her shoulder and then she just flung it forward.
And I'm just noting if we got to talk about the record, right? So you're saying that she got her arm back and threw it forward.
Yes.
And I guess just as a parallel, it's kind of like a football.
Yes. Correct.
It was not a fling using like a flick of the wrist.
Correct.
Okay. So after you interviewed, okay. Actually, before I move on from that, did she tell you the distance in which she flung the knife?
Yes.
Okay. What was the distance that she told you?
She said it was about 10 feet apart.
Did she point to the room?
Yes.
Okay. What was it that she said when she pointed to the room?
She said the distance was bigger than the room that we were in.
And so in that context, as if the room was 10 feet, it was longer than 10 feet.
Yes.
So she was at a distance of approximately 10 feet when she claimed she had flung this knife.
Yes.
And did at any point she say whether Mr. Obumseli was armed?
No.
No.
He wasn't armed.
Okay, so she did say, but he was not armed.
Correct.
So she acknowledges Mr. Obumseli was not armed in excess of 10 feet from her when she threw this knife at him.
Correct.
So progressing from that, during the interview of the defendant, you became aware that she was on the phone with her mother during the incident.
Yes.
What did you do as a result of that?
As a result of finding out that she was on the phone.
Yeah, after, knowing that she was on the phone with her mom,
Uh-huh.
and then you finished the interview, what did you do?
I was able to get in contact with the mother over the phone.
Okay. Did you do an audio recorded interview of Miss Clenney's mother?
Yes.
Okay. Were you aware that there was anyone present besides you and your fellow detective on that call?
No.
Okay. At what point did you become aware that there was someone else on that call?
When the attorney arrived at the station, her father jumped spoke from on the same call, saying that the attorney was there and that they would like for the attorney to be present for any more questions.
So during the length of your interview with her, you were not aware that she was with someone else in her person?
Correct.
As you were doing that interview, what did you ask Mrs. And I directed the court to the audio recorded statement that's in evidence, but again, will you please synopsize the contents of that call?
We spoke about the relationship between the victim and the defendant. And she explained to me that I believe it was about a week before the incident that the mother was there for 6 days because Christian wouldn't leave the house and he kept following her around. So she came down to Miami to see if the transition of him leaving the apartment would be a lot better than just them two trying to figure it out.
get away from her and that he was lying.
Correct.
Nothing more than that.
Correct.
Mrs. Clenney didn't say anything about owl that hurts or any indication that the defendant was injured in any way.
Correct.
Did Mrs. Clenney tell you the circumstances of the incident, how she knows the incident occurred or under what circumstances?
On the day of?
Yeah.
No.
Okay. At any point did she tell you she knows what happened?
No.
So having moved on from that, earlier we talked about how you were evaluating the case for possible self-defense.
Yes.
So what did you do as a result of, on the date of the incident, what did you do as a result of where you were at?
I don't understand.
In a nutshell, after you interviewed the defendant, you interviewed the victim,
Yes.
or rather, you interviewed the defendant, you interviewed the defendant's mother. Crime scene, photographed the scene.
Yes.
They documented her, you collected all pieces of evidence. What else happened that night?
Nothing else. We finished with the scene, and the defendant was let go.
Okay. Is
Released.
that normal protocol?
Yes.
Okay, why is that normal protocol?
At the time, we didn't have enough to say what actually did occur, and we still needed to continue the investigation.
Had a decision been made as to the defendant's criminal culpability at that point?
Well, at first, I was leaning more towards a self-defense.
No, we discussed that. My
Okay,
question was,
yes.
did you close the case and say it was self-defense, or was it still open?
No, it was still open.
Okay.
Yes.
So the investigation was still open, it was still pending. Okay, so what are the next steps you took in your open investigation?
Okay. Well, we did several warrants for everybody's cell phones, the victim and the defendant's cell phone. We did warrants for social media. And yeah, I believe a couple of other warrants as well.
As a result of some of these warrants, did you end up briefing the state attorney's office about the investigation?
Yes.
Okay. As pursuant to that briefing, were there subpoenas that were sought?
Yes.
I'm just going to go through things that are in evidence, but did you obtain police reports and body camera from Las Vegas?
Yes.
We're going to talk about this. I'm just going through everything. We mentioned warrants. You said on the phone. Which phones are you speaking about?
I'm speaking about the victim's cell phone and the defendant's cell phone.
Okay. Were you able to get the extraction from the victim's cell phone?
Yes.
Were you able to get the extraction from the defendant's cell phone?
Not yet.
Is that still pending and being attempted?
Yes.
From the extraction, were you able to obtain data and information?
Correct.
Okay, so we'll cross that bridge in a little bit. Pursuant to subpoenas, were you able to obtain surveillance footage and incident reports from one Pariso condominium?
Yes.
Did you also obtain lease documents?
Yes.
As part of those documents, were you able to obtain the FOG records?
Yes.
You mentioned warrants on social media. Was that the Instagram warrants?
Yes.
And is that how we know the precise time in which Ms. Clenney was live?
Yes.
Did at some point you obtain the call detail records of Ms. Clenney?
Yes.
Or the defendant, sorry. Even though I lost myself on that. At some point, did you obtain the criminal history of the defendant?
Yes.
At some point, did you obtain, pursuant to subpoenas as we were discussing, financial records belonging to the defendant?
Yes.
Now let's go back again. Date of incident, crime scene process. At any point, did you obtain a diagram of the apartment?
Yes.
Was that diagram to scale and measured and documented?
Yes.
Just noting for the court, Exhibit 19. Will you please describe to the court the crime scene? Again, the court has the photos, but just outline it for it.
Okay. The crime scene is an apartment located on the 22nd floor of the One Paraíso building. It's a 3-bedroom apartment with a single kitchen and living room. You want me to explain also where the scene was located, or?
Yes, please, if you don't mind. So
Okay.
let's parse that through. And actually, let's take steps in this. When crime scene enters an apartment,
Yes.
you tell the court the various photographs that they take, such as the
Yes.
initial scene, the measurements, and so on.
So before anything is done, we take all photographs from the first floor of the building to show what building we're going to. The elevator, the floor of the elevator that it stops on, the number that's fixed to the front of the apartment, the front door, and then all wide angled and far away photos of every room in the apartment. And then initially they started taking photos, closer shots of any blood or weapons or anything that has to do with the incident.
Will you please describe to the court I'm going to separate them into 3.
Yeah.
There's the 3 different blood scenes.
Yeah.
Will you please explain to the court what that means?
So the first one that we find is where we initially found the victim, which is the first puddle of blood. The second one was more towards the living room. And then the third one was, it was more between blood spatter and droplets that were moved around not moved around, but showed that the victim was walked around the apartment.
Objection, Your Honor.
So let's piece through that. So there were 2 pools of blood, which is 1 and 2 that we just discussed, and then the third where there was droplets and spatter.
Yes.
You described this one. I'm just noting for the record. The first one, the first pool of blood is where the defendant was located,
Yes.
holding the victim. The second one you said was further back, and it was just a pool of blood.
Yes.
Did you see blood transfer on the wall?
Yes.
Okay. What does that blood transfer mean?
Well, it can mean numerous things.
Okay,
But the one on the wall was it means that it's blood spatter, meaning.
No, I'm talking about the transfer. So
Okay.
the second pool of blood, if you recall,
Okay.
there was, again, I'm just noting the exhibit that's in evidence. There was blood on the wall,
Yes, I remember now.
and it was kind of filled. It wasn't spatter or drop. Do you recall that?
Not so much.
That's fine. Then we'll move on if you don't know. So let's talk about the blood spatter and the droplets. You
Objection,
mentioned
Judge, lack of predicate.
So we were last left off on the spatter and droplets. Do you
Yes.
know what spatter is? Like, just, can you describe that?
Yes, spatter is more of a way that the blood kind of like just if you stab somebody or
I'm not asking for the
if
point.
you swing any type of liquid, it makes a certain movement that it shows that the blood was traveling at a certain direction.
So how is it different from a drop?
A droplet is it's
Objection.
I'm not asking for conclusions. Judge.
I have a sustained, let's just
Sure.
stick with what is solved in the department and try to go back to at least some sense.
Okay. Did you see droplets throughout the house?
yes.
What does that mean?
Means that there was blood following straight down at a straight angle.
Objection, Your Honor.
And where did you see these droplets?
In the living room heading towards the bedroom, the master bedroom.
Just going back about the flinging of the knife. Do you have any information that the defendant knows how to throw a knife or is some kind of expert in throwing a knife?
No,
At any point in time, did Mr. Obumseli go to the medical examiner's office?
yes,
Was an autopsy performed on him?
yes,
Have you reviewed the contents of that autopsy?
yes.
Okay, let's discuss that autopsy. Who was the medical examiner that performed it?
Dr. Hutchins.
As a result of that autopsy, did he determine a manner of death?
Yes,
What was that manner of death?
by stabbing.
Okay. Did he rule the death any particular manner?
No. Oh, I mean, yes, homicide.
Okay. At any point in time, did you become aware that it was impossible to have thrown that knife? Or at least that was the opinion?
Objection.
I'm just asking.
Can you repeat the question?
At any point in time, did you become aware that the throwing of a knife could not have caused that injury?
Yes.
Approximately when? Like, where were you in your investigation?
I was later on in the investigation.
So let's talk about some of the other evidence that you obtained. So we discussed Las Vegas. Did you get a chance to receive those reports and review them?
Yes.
Just directing the court to the Las Vegas reports. At any point in time, did you review the body camera?
Yes.
Not to belabor the point, but will you please synopsize to the court what was in those reports and in the body camera?
In the reports that explained that the victim and the defendants were staying in a hotel room in Las Vegas. They got into an argument. Through that argument, the defendant threw a bottle of water at the victim while he was laying on the couch. And security was called to the apartment due to the argument.
Did you review the defendant's statement?
Yes.
To Las Vegas?
Yes.
In that statement, what did she say?
She says that she likes to throw things and that she guesses that she was the one that threw the bottle at him.
Did she acknowledge throwing items at Mr. Obumseli before?
Yes.
What were those items?
Plates and other items.
Was Mr. Obumseli interviewed?
Yes.
As part of that interview, did there come a time where the officer asked Mr. Obumseli a bunch of questions as to whether the defendant was violent with him prior to that?
I can't remember that right now.
Sure. I'll just direct the court to the video. Following the defendant's admission, was she arrested on that case?
Yes.
Let's talk about the cell phone extraction. Did you get a chance to review Mr. Obumseli's cell phone extraction?
Yes.
Will you please tell the court, what a cell phone extraction is?
It's pretty much just an extraction of all the data, messages, photos, videos, and even sometimes social media, saved posts can be extracted from the phone.
During, when you received the extraction from his phone, did you get an opportunity to review the photographs?
Yes.
Did you get an opportunity to review the videos?
Yes.
Did you get an opportunity to review the text messages between the defendant and Mr. Obumseli?
Yes.
I want to discuss with you regarding your review of those, and I'm going to bear with me because I'm just going to be very specific in directing you. You have all the records, just so we're clear.
Yes.
When they're produced, do they produce in a PDF? How do they come out?
They're produced in a PDF.
Do you recall how many text messages there were?
It was over 12,000. I believe it was 12,220. Something like that. Yes.
Do you remember from when to when those messages were?
Yes. Those messages go back as far as 2020.
Okay. You remember when? November, December, January?
I can't remember the month.
So from 2020 to April 3rd,
Yes.
The complete messages into 12,000 or so.
Yes.
Let's discuss the messages from, again, just going to be very delicate. October 9th through the 11th, which is in evidence of Exhibit 4. Did you get a chance to review those?
Yes.
Will you tell the court, again, just a synopsis because the court has them, what is covered in the messages between in State's Exhibit 4?
Mind if I review my notes really quick?
Yeah, if you need to refer to anything to refresh your recollection, go ahead and then let me know when you're ready. What was discussed on the October 9th through the 11th messages?
So, based off of the messages, there was an argument that occurred again. Mr. Christian writes to the defendant that she stabbed him, and he wants to get into the room, that he needs help, and she pretty much just told him go get first aid, and pretty much just brushed them off.
Later on in those messages, does he confront her about hitting him with a phone?
Yes.
Okay. Does he confront her about her spitting on him?
Yes.
Was it in the context of all of these messages where he also confronts her about stabbing?
Yes.
Did the defendant respond to these accusations from Mr. Obumseli?
Yes.
What did she say in response? You can review your notes, yeah.
Yeah, she pretty much just tells him to go get first aid. And then for several hours, she just didn't answer anymore till the next day.
At any point, does she apologize for her actions?
Yes, the following day.
And does she do it in the context of acknowledging the accusations?
Yes.
In those messages, were there any affirmative allegations by her to Mr. Obumseli
Yeah, she pretty much told him that she apologizes. She shouldn't have treated him that way. She shouldn't.
Let me cut you off. You
Okay.
didn't understand my question. My
Okay.
question was, did she make accusations about Mr. Obumseli? So, for example, he sent her a message about you stabbed me.
Yes.
Did she reply saying, well, that was because you were choking me?
I can't remember right now.
Did she make any accusations towards him at all in those messages?
She did, but I can't remember the specific
I'll
accusations.
direct the court to that evidence. Let's talk about January 30th to February 1st. Did you review messages from that incident?
Yes.
Okay, will you tell the court what that incident is about? That's Exhibit 5 for the record.
On those messages, the defendant was trying to reach out to the victim, and he pretty much just said, "Yes, Courtney." At that point, she didn't like the way that he wrote to her, and just started becoming very angry and asking him about why he said, "Yes, Courtney."
Were there audio messages associated with that?
Yes.
At any point in time, did he communicate to her that he had made a mistake because he was doing something?
Yes.
Okay, what was it that he communicated to her?
He explained to her that he was just trying to answer quick because he was watching the overtime on a football game.
Okay, do you know what overtime he's speaking about?
I believe it was the Bengals versus the Chiefs.
Okay, and so you're referring to the overtime of that?
Yes.
So at any point in time, did the messages continue, or was there a break in time between those messages?
There was a break.
Okay. At the end of the, argument over the tone of the messages and the next message, what is the next message that occurs in that break in time?
May I go back?
Sure. What was the first conversation after?
So the first one that I recall, it was the defendant telling him, "I hope this gives you time to think about what you've done." And then she tells him, "Enjoy the hospital." And then after a little while, he messages her, "I lost a lot of blood. Can you come? I need you." And then she asks him, "Are you having fun?" And this is all between him writing her that he's losing a lot of blood and at the hospital.
Were you able to find out what happened in that time period?
Yes, she ended up cutting him with a knife.
Okay. Now, how did you figure that out?
It was all in the messages that he wrote, and she responded back to him.
Were there also photographs from that date and time?
Yes.
And how is it that you figure out the date and time that a photograph is taken from the device?
So through the properties of the photo, it will show you when the photo was created, and it was at the same time and date as these messages were sent to him.
And just so we're clear, the messages or the photographs also had location information?
Yes.
Do you remember where the location of that was?
It was on the east side of the 195.
Okay. Is there a street that's there?
Yes, that's called the Julia Tuttle, but it leads up to the hospital. It was just it was pinpointing right at the hospital, Mount Sinai.
Okay. The state's directing the court to Exhibit 6. So in those photographs, you said it shows that his lip was sliced.
Yes.
And that the location of those photographs were at a hospital.
Correct.
Were you able to locate images of those injuries?
Yes.
Okay. Directing the court to Exhibit 7. Will you just describe the court to what those injuries were?
It was a large laceration that goes from the lip to the bottom of the chin.
Okay. And what is a laceration?
Say that again.
What is a laceration?
Laceration is it's a cut.
So there was a large cut from the
Yes.
chin to the lip, and there were stitches, you said.
Correct.
Did he appear to have any other injuries in that stitches photo?
Yeah, he had another small laceration here to the left, I believe the left of the face,
For the record, you're pointing
to the,
like at the cheek.
closer to the chin, to the cheek.
Okay.
As well as we noticed that on the photo with the stitches, he had 2 black eyes, or what you would call raccoon eyes.
Okay. So there was dark discoloration on his,
Yes.
on his face, by his eyes.
Correct.
And then at any point in time close to these incidents, was there another selfie of the defendant for comparison?
Yes.
Or not the defendant, excuse me, of the victim. State's Exhibit 8 for the record. Were there more incidents documented in text messages?
Yes.
Okay, let's discuss February 27th and 28th.
Okay.
What was documented in the text messages there directing the court's Exhibit 9?
Let me go back really quick.
Sure, you can look at your notes. All right, sir. What was discussed in the February 27th and 28th text message?
So during that time, the victim, he wrote a very large message to the defendant. He pretty much started explaining is love gonna kill him. Through that message, he explained how the defendant has stabbed him several times, hit him with a phone, with other items, calls him the N-word on several occasions. And in regards to hurt him, he says that he has tried his best to work through it, and that after he goes through, after he starts his seeing a counselor, a psychiatrist, that he's gonna leave her. But then he also went into explaining that if she was still willing to work through it, that he would still want to work through it.
Following this, did the victim begin documenting audio and video recording incidents between him and the defendant?
Yes.
Were there any of these documented incidents before this text message? This lengthy text message? By that I mean secret recordings, right? He started
Yes.
secretly
Yes.
recording her.
Yes.
Prior to this text message, did he secretly record her?
Yes.
Okay. He did?
Yeah.
Okay, when did he secretly record her before this?
I can't remember the dates.
Okay. After this date, for certain, he did.
Actually, let me review.
Sure, go ahead. If you need to review your notes to refresh your thoughts.
I don't have those with me right now.
So you said you don't have them, as in, does that mean that you're
No,
not sure
no.
if you recorded her before?
Correct.
Okay. So you're not sure if you recorded her before February 27th, 28th, but you're certain that he did after?
Yes.
Just directing the court to State's Exhibit 11 and the court's prior rulings. Sir, you're aware of a series of videos that the state has entered into evidence that was discussed here earlier.
Yes.
I'm not going to kind of publish those in air because the court has already had them, but would you just generally describe those 3 videos?
So on one of the videos, okay.
So Detective, as we're talking about, State's Exhibit 11 includes 3 videos and the metadata of 4 videos.
Yes.
Those 3 and another one. Again, the court has State's Exhibit 11, but for purposes of our record, will you just describe generally the 3 videos that were entered in State's Exhibit 11?
So one of the videos, they're in the lobby, and the victim had just explained to her, like, why are you hitting me? You shouldn't, you can't be hitting me like that. And then she lowers her voice, and tells them, shut the fuck up, bitch. And then he continues to ask her, why are you doing this? Like, calm down. And that was the end of that video. The other video, she was having some sort of tantrum in the apartment and yelling to the top of her lungs. And at one point, she calls out names using the N-word towards the victim. And she also even tells him, come here, let me slap you. And then also continues into telling him, find my phone, get me alcohol, get me alcohol.
During those recordings, did she also express, I guess, a jealousy of anybody?
Yes.
Okay, will you please explain?
She, according to the video, he acknowledged somebody in the lobby or just in front of the building when he went out to I believe it was to walk his dog. And he didn't tell her that he acknowledged somebody downstairs. And then that's when she just went into this continuous screaming for several minutes.
Now that we've discussed that context, I want to talk about building-specific incidents at One Paraiso and how they documented these incidents. Did you receive a lengthy amount of records from them?
Yes,
Okay. Do you remember approximately how many pages?
too many pages.
Too many pages. Okay, fair enough. As part of that, did these reports contain with them photos, videos, audios?
Yes.
These photos and videos, you describe them to the court how they looked on these reports.
No, I can't remember too much about the
Sure.
those records.
Were these videos and photos and audio recordings, were they original or were they like pictures of videos and things like that?
If I can remember correctly, they were original from the actual video.
And are you referring to a February 21st incident?
Yes.
Okay. Again, that's State's Exhibit 10, I'm directing the court to, but will you please describe it for the court again for our record purposes?
So at one point, the defendant walks downstairs or takes the elevator downstairs. Shortly after, the victim goes downstairs as well. Several minutes later after that, the victim comes back to the elevator. It opens, it closes. I guess he went to go back to look for the defendant. Eventually they come back. She enters, then she's trying to click on the on her floor, but she can't because she doesn't have the key fob. So the victim comes in. He's trying to put on the key fob, and she goes into she begins to attack him, pull his hair. She at one point tries to swing at him with a closed fist. So he ends up kind of like holding her down so he can use the key fob and go back upstairs to their respective floor.
Let's parse that through. You mentioned earlier about having received the key fob and directing the court to Exhibit 13. How many key fobs did that apartment have?
2.
Okay. Do you recall which one was Christian's?
Yes.
Okay. Which one was Christian?
Christian's is the one that ends in it's 01027.
And then and that's the serial number.
Yes.
Okay. What was Courtney's key fob?
It was 01058.
Okay. How can you tell which one's key fob was whose?
So the defendant's key fob has been inactive because she lost it, and it's been inactive since as of I believe it was March.
So
and
February 21st, she still had her fob.
Yes.
And how do you know that she lost it? Was that a message?
It was in some of the messages.
Okay. So both Christian and Courtney had key fobs.
Yes.
And so she lost it, you said March 20?
Yes.
Or rather March of 2022. Jesus.
March of 2022.
And so February 21st, 2022, she still had the fob.
Correct.
Let's walk through that video. When she enters the elevator right before Christian does, is she holding the door or is she trying to close the door?
She's trying to close the door.
Okay. At any point, does she put her hand over the door?
Just before he made it.
Okay. So she had her hand over the door right before he entered.
Yeah, right before he entered, she put her hand through the door, or on the side of the door, so it can stay open as he walks in.
Okay. And you did go to this apartment.
Yes.
So that door has the sensor.
Correct.
In the video, you said that you can see her tapping the screen.
Yes.
Did you, again, having been in the apartment, you saw how that system is set up?
Yes.
Are you familiar with it?
Yes.
Okay. So her tapping the button, would that have achieved anything?
No.
Okay. Why not?
Because you need to scan the key fob first in order to be able to go to your floor.
So then you said that Christian walked into the elevator and kind of told her to stop banging.
Yes.
What did he do then?
He was trying to tell her to stop. She begins to swing at him and try and pulling his hair. So then he kind of like pushes her to the side to try and use the key fob. She continues to jump on him to attack him some more. So at which point he kind of like just holds her down, like bends her over and holds her down so he can finally hit the key fob and click on the right floor.
At any point in time, did Christian exercise, I guess, affirmative violence towards the defendant?
No, he's just more trying to like keep her away from hitting him while he gets upstairs.
Now, date of incident, you received the surveillance video too from the building.
Yes.
Besides capturing Christian leaving, returning, and so on, did the surveillance video from the building capture anything?
I'm sorry, say that one more time.
Besides capturing Christian leaving and then returning, did the surveillance video capture anything about this incident, any violence or anything else?
No.
One second. Your Honor, there's some testimony that I would elicit that pertains to phase 2. I guess my question would be whether the court wants me to go into that now or wait. Sure. At some point in time, we mentioned how the initial impression date of incident was that it was a possible self-defense. And for the last 45 minutes or so, we've been discussing all the subsequent investigative steps.
Yes.
Did these subsequent investigative steps change your outlook of this case?
Yes.
Okay. How did it change?
It changed the fact that I learned that Christian was always the one trying to calm the situation down. Based off of of messages and everything, he was always the one that ends up getting hurt. And the defendant is just the one that's always unable to control herself and hurt him.
As a result, did you apply for an arrest warrant?
Yes.
Was that
Yes.
noted directly in the court states exhibit 1? As a result of that arrest warrant, were efforts taken to locate Miss Clenney? Excuse me.
Yes.
Who assisted in locating Miss Clenney?
The marshals.
Okay. Why were the United States Marshals asked to locate Miss Clenney?
Because she was out of our jurisdiction.
Okay. Where was she?
In Hawaii.
Okay. Do you remember where in Hawaii?
Hilo, Hawaii.
Okay. Did as a result of her arrest, did you travel
Yes.
to Hawaii?
Yes.
How long did it take you to travel?
It took me about 24 hours to get there.
Okay. How many flights?
3.
And actually, before we go too far down drift, when you received the One Bariso lease records, did you receive a letter documenting the defendant's move out?
Say that again?
Did you, within that packet, was there documentation about the defendant moving out of the apartment?
Yes, they were in the process of
Did the records document that she moved out by April 28th?
I don't remember.
I'll just direct the court to the exhibit for the record 28th. So the defendant had moved out of Miami, was located in Hawaii. Because she was in Hawaii, Actually, let me back that up. Do you know how she was located in Hawaii?
No, not really.
So she was located in Hawaii, was apprehended in Hawaii and extradited to Miami. Did you, I guess, as a result of this investigation, were there subpoenas that were prepared obtaining the defendant's financial records?
Yes.
Okay. Let's discuss those financial records. Have you reviewed them?
Yes.
Okay. Directing the court to the financial records, which I believe are States Exhibits 29, 30, and 31. Did you at any point in time get a chance to review those records?
Yes.
Approximately how much, and then States Exhibit 32 is Bank of America records. Did you get a chance to review those?
Yes.
During that time, immediately before the murder, approximately how much money did the defendant have in the bank account?
I believe she had just over $2 million.
Again, just to direct the court to the exhibits, but roughly. At any point in time after the homicide of Christian, did the defendant make transfers of that money?
Yes.
Okay. Please tell the court.
She made two separate money transfers over to her father's.
And that was 9 days ago?
Yes.
Did she make any other transfers after that, if you recall?
I don't recall.
Besides those large wire transfers, we discussed briefly earlier, we discussed the defendant's criminal history.
Yes.
Will you please tell the court the defendant's criminal history and directing the court to Exhibit 25?
Well, she has the battery out of Las Vegas, and then she has DUIs out of Texas, and then I believe also out of California.
Did the defendant, so let's talk this through, right? So she has a 2015 DUI from Texas, and then you said it's something from California.
Yes.
Was the California case, did she pick up that case while the DUI was pending, the first one?
Yes.
And then you said she had a second DUI in Texas, and then for the record, it's September 16th in 25. Did she pick up the domestic violence battery on Christian in Las Vegas while that case is pending?
Yes.
Do you know if 2020 DUI is still pending in Texas?
I believe so.
And do you know if the defendant has a warrant for that case?
Yes.
One second. And just to finish up, the wire transfers from the defendant's account to her father, did that essentially deplete her bank account?
Mostly, yeah. She just left some money for herself.
Stay at home for the question.
Write your first and last name. Thank you. Thank you.
Grab a seat for the restrooms. Right? Nobody in the room? I'm not in Miami for longer than 24 hours. When I came back from vacation, I thought, man, a car hit my car, but it was the worst kind of Miami accident. So like, I'm right here. This car is stopped right there. No reason. I don't know what you're doing. I'm just traveling, going this motherfucker decided to
Make a left and hit you.
and hit my tire. Thank God. No, my car's fine. Literally, it was like a shopping cart.
How did they do?
No.
They doing taking a break?
I'm taking a break. Thank you for taking another week.
So, just for your own edification. Tell me this is here.
Oh.
Yeah, listen, they're watching. They're looking at it. Sorry. I'm stealing his thunder. I'm sorry. They're looking at it.
You can't come in here and try to act on my
Oh, you always gonna take his side.
Of course.
Damn, it's like that. Can you believe that?
And I've been knowing him.
It's just like all the people that
Oh, that's on the staff.
I'm good. How are you?
When you get it wrong. Oh, yes. Absolutely. You have a flash drive?
Yes, I do.
I'll do that right now.
Let me go answer this before I leave. Let me go look at it.
Same supervisor.
Take her picture. Make sure you take her picture.
I paid it off. Oh, because she.
There's a few things going on. We need them. I'll let you need them. We'll go check on county court. Yeah, travel. County court, y'all, there's a few things going on. Mhm.
Maybe support. Good afternoon, Detective.
Good afternoon.
Detective, we just start. We've met before, right?
Yes.
And the first time we met was at the City of Miami Homicide Bureau, correct?
Yes.
I showed up there.
Yes.
And we had a conversation, right?
Yes.
And after our conversations and after I spent some time with you and with Courtney, I believe I gave you my phone number, correct?
Yes.
You have my contact information. Is that fair to say?
Yes.
And I also communicated with a Detective Jerez, who was part of your team that night, correct?
Yes.
At what time do you recall did Detective Jerez let you know that there's an attorney who's representing Ms. Clenney?
It was later in the afternoon.
Later in the afternoon?
Yeah.
And did she notify you by text or by phone call?
When we spoke in the station.
So she notified you orally?
Yeah.
Verbally?
Yeah.
What time did you start the interview with Ms. Clenney?
I want to say like 6 or 7, possibly.
And I think The interview would have been video recorded, correct?
Yes.
And in that video recording, it has a timestamp, correct?
Yes.
So the best evidence for that would be the timestamp on the video, right?
Correct.
I don't want to hold you to a time unless you know 100%.
I don't know
Fair?
100%.
Okay. Would that be noted in one of your reports?
Yes.
Now, when you started your interview of Ms. Clenney, you already knew that Mr. Obumseli was deceased, correct?
Yes.
You did not tell her that, correct?
I did not.
About how many times would you say she asked about how he was doing throughout the course of that interview?
Several times.
Several, more than 3, more than 5, less than 10?
About 3 or 4 times.
And what did you tell her every time that she was asking about how he's doing?
That he was just at the hospital and they're still working on him.
And so that's not the truth. That was a lie, correct?
Correct.
Now, you've produced a report in this case, correct? I think it's, you read it at 310 or 301?
Yes.
And what kind of report is that?
That's just a brief report on the investigation.
Okay, and so you have not prepared a final homicide report, correct?
A supplement? No.
No. And are you working on that?
Yes.
And when will that be available for disclosure?
When I, hopefully soon.
Okay. And the contents of that report are going to be consistent with what you're saying here today, correct?
Yes.
And there's not going to be anything added or anything different, correct?
No.
Prior to conducting the interview with Ms. Clenney, did you conduct any background investigation, speak to any other potential witnesses or anything like that prior to conducting her interview?
No.
Did you arrive at the apartment? Was that
Yes.
your initial arrival point, I believe?
Yes.
Okay. So were you able to view the condition of the apartment at that time, or did you go back later?
I briefly looked at the apartment, the condition first, and then I went back later on and looked at it again.
Okay. And did you speak to any of the first responding officers prior to conducting your interview with Ms. Clenney?
Very shortly.
Did they mention to you that she was in a state of panic at the time?
Yes.
When they first showed up?
Yes.
She was covered in blood, right?
Yes.
Which was consistent with, I think, what you said you reviewed some body-worn camera. That would be consistent with her cradling Mr. Obumseli in the living room area, correct?
Yes.
And did the other responding officers, well, let me ask you this. What was her mental state at the time that you first spoke to her?
When I spoke to her, she was more calm than when she was at the building. But she was still a bit shaken up due to what occurred.
Which that would be kind of a normal human reaction, right?
Yes.
Now, also, I believe in the body-worn camera, let me ask you, have you reviewed all the body-worn camera of all the responding officers that evening?
Not all of them, most.
Okay. And a lot of them, Courtney's expressing her concern for Christian, right?
Yes.
And she's in a state of panic. What would you call it? Again, and her dogs are running around the apartment barking. It's a very hectic scene, right?
Yes.
Now, you heard or you saw, I think when you were testifying in direct, a clip of part of Ms. Clenney's statement, correct?
Yes.
And she describes the attack on her by Mr. Obumseli, correct?
Yes.
There's nobody else in that apartment at the time, correct?
Correct.
There's absolutely no eyewitnesses to what occurred in the apartment on April 3rd, 22, correct?
Correct.
So your investigation, it focuses around what happened after, basically, right?
Yeah.
Now, the part of the interview that we saw, that was actually the third time that you asked her to kind of recount her. And the first time, do you recall what she said the first time?
It was about the same as the one played on the video.
Okay, so, I mean, there was an argument, right?
Yes.
And your subsequent investigation showed text messages and some calls for, and I'm talking about April 3rd, 2022. We'll get to the other stuff later. But on April 3rd, 2022, you have the video of them in the morning. Doesn't seem like there's anything wrong.
Yeah.
Right? You have some text messages and some calls that occur right before that.
Yeah.
Right before around 4:30 p.m., correct?
Yeah.
Okay. And then we know things go bad, right? Yeah. We know that because some neighbors called the police, right?
Yes.
They heard screaming and yelling.
Yes.
Right? We know that your investigation also revealed that Courtney was actually on the phone with her mom, right? Deborah
Yes.
Clenney. And she was actually on the phone with her at the time that Christian received the wound, correct?
When he received the wound?
Yeah.
Possibly, yes.
Okay. And so when Courtney's recounting what happened, she talks about a physical struggle with Obumseli, right?
Yes.
How big, meaning how tall is Mr. Obumseli?
He's taller than her.
Is he 6'2"?
Yeah. Low 6.
Low 6
6'1",
foot?
6'2", something like that.
How much does he weigh?
I want to say about 200 pounds. Well,
Okay. And
180.
how tall is Courtney Clenney?
She's about 5'8".
And how much did she weigh at the time?
About 140, 150.
Okay, so Obumseli outweighs her by about 60, 70 pounds and is much taller, right?
Yes.
Now, she describes his attack on several occasions. I think the third time, right? She mentions that he got in a crouching position where he was crouching and then he came at her, right?
I don't remember that.
No, that's not her statement?
I don't remember that.
Okay. Do you remember her saying she could see the whites of his eyes?
No.
Did you review her statement before coming here to testify today?
Objection, counsel testify. Also argued.
I reviewed part of it.
Part of it, not the whole thing. So again, but you're saying her testimony from the first time you asked her to recount what occurred was similar to the third time, right?
Correct.
In the arrest, did you author this arrest warrant? And I'm holding it up. It's been admitted into evidence, and Judge, procedurally, I would move to submit, try to move into evidence all defense exhibits which were previously provided to the court. I believe
I have no objection.
defense exhibit A, I believe, was the arrest warrant.
I don't have any evidence from the defense.
Wait, I'm sorry, hold on. I misunderstood something. Can we approach that part?
Detective, I think I was about to ask you about this, the affidavit in support of the arrest warrant.
Yes.
Did you author that?
I did not.
You didn't author
No.
the arrest warrant in this matter?
No,
Did you sign it?
I did.
You're the affidavit, right? You're the one swearing to this document?
Yes.
Did you read it?
Yes.
Did you go through it
Yes.
line by line?
Line by line.
Did you understand what was contained in this document?
Yes.
Let's go through the mischaracterizations of the evidence that are contained in this. I believe the first one in this affidavit, you talk about, and this is going to be, and please let me know if you need to see this. This is Defense Exhibit A. I think the government also introduced the arrest warrant. And this is on page 4 of 6. This is the second full paragraph. You stated, in her explanation to the police regarding the content of the phone calls that day, D. Clenney, which is Deborah, did not say she discussed the incident with the defendant. However, investigators know D. Clenney did communicate with the defendant about the incident because investigators saw a text message from mom on the defendant's phone reported at 5:25 p.m. that mentioned self-defense and advised her not to say anything to investigators without an attorney. In addition to omitting her conversations with defendant D. Clenney, in addition to omitting her conversations with defendant D. Clenney, recorded statement also admits any claim that the defendant said she was being attacked by the victim during the call. Do you stand by those words?
Can you read the last sentence one more time?
Yeah, I was going to object to this characterization because it said admits versus omits, which is what the warrant said.
In addition to omitting her conversations with defendant, D. Clenney's recorded statement also omits any claim that the defendant said she was being attacked by the victim during the call.
Correct.
Okay, you stand by those words?
Yes.
Okay. In your phone call to Deborah Clenney, did you ask her, hey, was Courtney attacked?
No.
Okay. So when you say she omitted it, you never asked the question, did you?
Correct.
You also, in this paragraph that I read, you indicated that D. Clenney, meaning Courtney's mom, did not communicate, or the investigator, that Deborah Clenney did not say she discussed the incident with the defendant, meaning the attack, right?
Correct.
Okay. You didn't ask her about that, did you? Did you say, hey, did Courtney tell you about the attack?
No.
No, you didn't ask her that, right? So any omission is because she didn't volunteer it, correct?
Correct. Now,
while you're, I guess this paragraph says, while you're interviewing her, I guess you saw a phone, a text message kind of pop up on Courtney's phone?
Yes.
And were you able to view that? A text message popped up on the phone, and I guess you're saying this mentions, and it mentions self-defense?
Yes.
Did you see the entire text message?
I did not.
One moment. So your inclusion of that portion that says something about self-defense, it kind of makes it sound like that's something nefarious or somebody's being coached, right? The way you wrote it? These are your words that you adopted, right? It kind of makes it sound like there's a cover-up, right?
Yes.
And you put these words in here without seeing the full and complete text message, correct?
Yes.
Now, on the screen here, I think it's Defense Exhibit C, right? This is the complete text message. At 4:04 p.m., which would be Texas time, so that would be 5:04 p.m., okay, Miami time. Please tell me what's happening. This is from Deborah to Courtney, my sunshine. Please tell me what's happening. You have to call me, exclamation point. Even though it was self-defense, don't say anything with the police without getting a lawyer first. Call me, please. It's very important. Even though it was self-defense, you cannot say anything without an attorney, exclamation point. Innocent people get in trouble all the time. Right? That's the complete message. And this is a mother, right, that's in another state, right?
Objection, counsel testifying, no question pending, both to everything that we just said and now.
Sure. Do you know where Miss Clenney was, meaning Deborah Clenney, on the date of April 3rd, 2022?
Yes.
And where was she?
Texas.
And where was Courtney?
In Miami.
Okay. So what seems clear to me, and correct me if I'm wrong, but it appears that Miss Deborah Clenney was unable to contact her daughter at least between 5:04 p.m. Miami time, and then even going into the late night of 10:46 p.m. There's no responses, right, by Courtney?
Correct.
So this could be a very concerned mother, correct?
Yes.
Okay. And Deborah was on the phone with Courtney listening to the argument that night, right?
Yes.
And I believe she told you that when you interviewed Miss Clenney, Deborah Clenney, that she could hear Christian yelling.
I believe so.
Again, you weren't in the apartment that night, were you?
No.
Now, you testified previously that her first and third recitation of her statement of what happened that night about the attack was consistent, correct?
Yes.
This is page 4 of 6 of the arrest warrant whose language you adopted. Actually, you know what? Let me stop you there. If you didn't write this, who wrote this?
State attorney.
Which state attorney?
Khalil.
Mr. Quinnen?
Yes.
Now, in this paragraph, which is the third full paragraph, again, page 4 of 6, you say, although the defendant admitted to having caused the victim's injury in her post-Miranda reported statement, she also provided several inconsistent accounts about the incident. Now, you just testified that at least the two of the three are consistent, right?
Mostly.
So this could be perceived to be a little bit misleading then, correct?
No.
You had crime scene, or somebody had crime scene respond to the homicide bureau, correct?
Yes.
And I think I may have been there when they came to photograph her.
I can't remember.
I can't remember either.
Yeah.
It's neither here.
But-
nor there. Sorry, I'll move on. So they came. Sorry, I forgot where it was. So crime scene did come out to the homicide bureau and they photographed Miss Clenney's physical condition, correct?
Yes.
And that is done to document any injuries, right?
Yes.
You don't take the photographs yourself, do you?
No.
These crime scene technicians are specially trained, correct?
Yes.
And they have like rulers that they can take out to measure things when they're taking photographs, correct?
Yes.
Okay. And in your warrant, well, in the warrant that you signed, again, the last full paragraph, the defendant's physical body was documented on the date of the incident, and there were no injuries to her person to corroborate this account. Now, do you recall that being included in the warrant?
Yes.
Okay, and that's for the record and for your honor, it's page 4-6. Now, on the screen, which is Defense Exhibit H, these are crime scene photos, are they not?
Yes.
And these are taken by your department, correct?
Yes.
And these was then provided to the state and then provided to the defense, right?
Yes.
Okay, on the left side of the screen, there seems to be a bruise on the inside of her right arm. Do you see that?
Yes.
Could that bruise be consistent with a physical altercation?
At some point,
Objection
yeah.
and proper opinion. Is that next?
Do you see a bruise, a visible bruise on Courtney's inside, sorry, that's the right arm? Do you see that?
Yes.
And on the right side of the screen, it looks like it could be an abrasion. I don't know, there's a mark there that we circled on the right shoulder. Do you see that mark?
Yes.
Could that mark be consistent with some kind of physical altercation?
Yes.
We also have crime scene photos. Again, the inside of the right arm. This is I think the closer up view of what we saw a second ago. And in this picture, there's a ruler, right?
Okay, yes.
And if you need to get up with your Honor's permission, if the witness needs to get down, thank you, Judge. And they measure that just so there's some type of kind of comparison, or if they need to describe the extent of an injury, right?
Yes.
And they take that out for something that they think is important to document, correct?
Yes.
So then we go on the lower, again, another crime scene photo, lower right leg that we've taken the liberty of circling. There seems to be some discoloration there, correct?
Yes.
And that could be bruising, maybe not. You're not an expert, right?
Correct.
So these pictures actually do show signs of physical injury, right?
Yes.
Judge, can we approach that bar?
I'm going to do 20 seconds, sorry.
Thank you, Your Honor. Now, Detective, on direct, you testified that the medical examiner said that basically throwing a knife from that distance in that manner couldn't have caused that wound. Is that basically a summary of what he told you?
Yes.
Okay. Are you a knife expert?
No.
Is the medical examiner a knife expert?
I don't know.
Now, in the when the state was up here asking you a question that this has to be a stabbing, he motioned in a very almost a 90 degree motion, downward stabbing. Do you remember that?
Yes.
Now, is what the government, the state attorney, was that gesture, is that accurate and consistent with what the medical examiner's report says?
Yeah.
Really?
Yeah.
Detective, did you review the report from the medical examiner?
Okay. So objection and proper indication. also going to be miscarriage.
Detective, you did review the medical examiner's report, correct?
Yes.
And his report indicates that it is a slight downward angle, correct?
Yes.
Now, you testified on direct that you didn't see any bruising or marks around Courtney's neck, correct?
Correct.
In her statement to you, she did mention that he grabbed her by the neck or had her up against the wall by the neck.
Yes.
And have you ever seen a particular situation where somebody could have their forearm up to somebody's neck,
Yes.
and that wouldn't necessarily cause bruising, would it?
Objection, Judge, that's a speculation.
And Ms. Clenney indicated also that at some point he threw her down to the ground, correct?
Yes.
Before? And I think she said on her shoulder.
She wasn't able to explain to me how he put her on the ground.
Right, I think she said something, and then I was on the ground, right?
Yes.
Okay, which somebody who's just experienced a traumatic experience that Courtney experienced, that wouldn't necessarily mean that she has an accurate memory, correct? Detective, have you ever been in a fight before?
You answered? Okay. Yes.
And was it a traumatic experience?
I mean,
Do you remember every detail about that fight?
well, I grew up doing martial arts, so yes.
In Courtney's statement at some point, she said she was able to break free, correct?
Yes.
Or she was able to get up, right?
She wasn't able. She was able to. She explained that he wasn't on top of her anymore, but she was able to get out, but she couldn't explain exactly how.
And you testified again after looking at the crime scene, after speaking to Ms. Clenney that night, after you spoke with me, you were looking at this case as a case of self-defense, correct?
Yes.
Now, as part of your investigation, did you try to canvass the area to find other witnesses?
We attempted to contact other members of the building in the same hallway as well.
And were you able to locate the witness that said he saw Christian hitting Courtney in the head prior to April 3rd, 2022?
I could not find him.
But you heard about that witness, correct?
Yes.
It was reported to you by somebody else, right?
Yes.
And I believe that account was told to you that that person wasn't sure if it was a closed fist or an open hand, correct?
Yes.
But so you do have some evidence, right, throughout the course of your investigation that at a minimum, Obumseli also hit Courtney at least once that you're aware of.
From what I was told, yeah.
Did you also interview any witnesses, neighbors in this case?
I attempted, but they refused to talk or be involved.
When you say they refused to be involved, what do you mean?
Like they didn't want to talk to me or give any type of statement.
And that was all the neighbors in the building?
Not in the building, but actually, hold on. I did speak to two gentlemen.
Okay, you did speak to two witnesses, right?
Yes.
One whose initials are JS and another one's initials who are EB, correct?
I can't remember right now.
Detective, so the, I don't want to necessarily put their names on the record now, but one of the witnesses, JS, I guess. So the first person you interviewed, remember the first gentleman you interviewed? I don't want to play your whole interview. I have some excerpts that I'll play later for the court so we can move through this. But in substance, would you agree that that individual basically said he had seen incidents of, I think, Christian Obumseli chasing or running around Courtney's car trying to gain entry? Do you remember that?
Yes.
Okay. And that same individual also, in that same interview, said basically, look, I know a victim of domestic violence when I see one, and Courtney was a victim of domestic violence, right? Correct. I mean,
If that person's opinion is improper, and the way they express it is improper as well.
that interview, in your interview of that individual, he opined, in his opinion, right, that Courtney was a victim of domestic violence. Is that true?
Yes.
Now, you interviewed another gentleman. I think it was just right after that.
Yeah.
And that individual recounted the scene at the dog park, correct?
Yes.
And in that recounting of that scene, right, he talked about Christian grabbing her aggressively in the tricep area, correct? And he also told you that he stayed around and stayed in case something, quote unquote, went down, correct?
Yes.
Because he was concerned.
Yes.
And I think he also mentioned that Christian had his hands up her face, correct?
I don't remember.
Now, I want to go back to the phone interview that you had with Ms. Clenney, Deborah Clenney. You remember that?
Yes.
And actually, you never asked the questions about to describe the attack and do the stuff before. You remember that?
Yes.
And part of that is because I showed up at the homicide bureau, and that kind of ended the phone call, right?
Yeah.
Right. I mean, you were kind enough, you were very cordial with me, very, very professional with me, and you allowed me to come in, right?
Yes.
And that terminated your call with Ms. Clenney, right?
Yeah. I mean, we were pretty much almost done with the call.
Okay. And in that, well, you never called Ms. Clenney to follow up and do another interview to get more details?
No.
With me, and you allowed me to come in, right?
Yes.
And that terminated your call with Ms. Clenney, right?
Yeah. I mean, we were pretty much almost done with the call.
Okay. And in that, well, you never called Ms. Clenney to follow up and do another interview to get more details?
No.
You never called her husband Kim to maybe follow up because you said he was on the line. You never followed up with him, right?
No.
You didn't call me and say, hey, can you talk to Deborah Clenney and have her make a statement to me?
No.
But what she did tell you was she overheard Courtney saying, stay back, right? Stay back.
Yes.
And then we know, based upon your cell phone analysis, right, that Courtney called 911 herself, right?
Yes.
And we heard it. She's there panicking, trying to get help, right?
Yes.
And again, when the first responder showed up, she was cradling Mr. Obumseli in her arms, correct?
Yes.
Now, you also served, well, let me ask you this. Did Courtney, during your interview, she was remorseful, right?
Yes.
Objection, relevance.
Right? She seemed remorseful and genuine with you, correct?
Yes.
Objection calls for credibility of the witness needs to strike.
Now, you said you executed some warrants in this case, one of which was financial documents, right?
Yes.
And those financial documents were of Courtney?
It was a subpoena, and yes, it was a court.
Okay, and you got a response, right?
Yes.
And, did you serve a subpoena on Obumseli's bank accounts?
No.
Why not?
No reason.
Do you know how he was supporting himself?
I don't recall.
Objection, relevance.
Did your investigation reveal that he was a cryptocurrency trader?
Yes.
Yeah. And all line of inquiry here.
I'll move on to a different line of questioning. You did serve a subpoena though on the building, One Paraiso, correct?
Yes.
And as part of the documents you returned, you obtained a lease agreement, correct?
Yes.
And whose name is on that lease agreement for the apartment where this incident took place?
The defendant.
Courtney's name?
Yes.
Is Obumseli's name anywhere on that lease agreement?
No.
As part of you serving subpoenas on the bank accounts and financial records of Courtney, did you see the payments being made for rent?
I can't remember.
Do you have any evidence that Mr. Obumseli ever paid rent?
Okay, Judge Relevance.
I can explain the relevance. Did you find any evidence that Mr. Obumseli ever paid rent?
No.
Now, part of your investigation also revealed that the week prior to April 3rd, 2022, Ms. Clenney had to fly in from Texas to help Courtney get him out of the apartment, correct?
Yes.
And at some point, he was thrown out of the apartment, correct?
Yes.
And then he came back, right?
Yes.
So during the time that he was out of the apartment when Ms. Clenney was there, do you know where he stayed?
No.
Did you interview any of the employees of the building that said he was living in a common area inside the building?
Objection, counsel. There's two questions within that one question. One of which is that
Did your investigation reveal at any point that Mr. Obumseli was staying in common areas within the One Paraiso building?
Yes.
Now, you discussed the manner in which you get up to the apartment in the elevator. Is it fair to say that you have to have a key fob in order to get into a specific apartment?
Yes.
And that particular fob is programmed only for that particular floor or apartment, correct?
Yes.
And the elevator, when it opens up directly into the apartment, correct?
Yes.
So once somebody gains access to the elevator, activates the fob, the next stop is the apartment,
Yes.
right? Now you testified about an elevator video, the infamous elevator video.
same objection as judge.
You previously testified about the elevator. I understand. You previously testified about the elevator incident where you say Miss Clenney was attacking Christian.
Yes.
Okay. You just have the video, right?
Yes.
What happened before they got in the elevator?
We don't know, or I don't really recall what happened before.
You don't know what happened before that elevator video, correct?
Yes.
Did you interview any witnesses that told you what happened before that incident in the elevator?
No.
So all you have is a video.
Yes.
No context to what occurred prior to Courtney getting on that elevator, correct?
Correct.
Now, she seemed pretty upset in that video, correct?
Yes.
And at some point, Mr. Obumseli is able to gain access to the control panel to get the fob, correct?
To use the fob, yeah.
Right. And that fob would take him directly into the apartment, correct?
Yes.
So the only way to get Mr. Obumseli not to go to that apartment would be to not allow him to use the fob, correct?
Yes.
Do you know if Courtney wanted him in the apartment that evening?
Judge, that's speculation.
Again, that was about a month and a half prior to April 3rd, 2022?
Yes.
As part of your investigation, did you review body-worn camera footage of an incident that took place at the One Paraiso condominium on April 1st, 2022?
I did, but I don't remember what was on it.
Would that video, if you can recall, would that video have depicted some officers responding to a domestic dispute?
Yes.
And in that video, do you recall Courtney explicitly saying, "I want a restraining order against Christian Obumseli"?
Yes.
You didn't put that into any of your reports, did you?
Not yet.
Now, Detective, in April of 2022, you had been with the homicide unit for less than 1 year, correct?
Yes.
Prior to that, what was your assignment?
I was in robbery.
And prior to being a robbery, sorry, I cut you off. I didn't hear your response. You were a robbery detective and you were going to say something else.
No, that was just it.
Prior to being assigned to the robbery unit, where were you?
I was in the problem solving team. I was in the problem solving team in overtime.
What? I'm not familiar. What is the problem
That's
solving?
just a unit that proactively works on ongoing issues within the community.
Okay. And prior to that, I'm going to guess you were on patrol street?
Yes.
Okay. In a marked unit?
Yes.
Okay. During the course of your experience while being a police officer, did you run into victims of domestic violence?
Yes.
Objection, relevance.
Are you familiar, let me ask you this, when you're in the police academy or as part of your ongoing training as a police officer, are you trained to notice signs of domestic violence?
Same objection. Also, improper opinion, I can keep going.
I'm asking if he's been trained or not. I understand. Have you been trained on detecting signs of domestic violence?
Yes.
Are you trained about what they call the cycle of violence?
Objection 702.
As part of your investigation, you indicated that you also subpoenaed or obtained police reports from Las Vegas, Nevada, correct?
Yes.
And you talked about that at length with the state attorney on direct examination, correct?
Yes.
And in your subpoenaing of those records, in addition to the police report, also came a statement, a sworn statement by one of the hotel security officers. Does that ring a bell?
Yes.
And in that report, well, let me ask you this. Did you review the body-worn camera of that incident?
Yes.
And I believe the investigating officer was Detective, or I think Officer Velasco?
He was an officer. I don't remember the name.
Okay. And this is the video, just so we can make sure we're talking about the same one. The video of the officer who first goes to see, I think speaks to Mr. Obumseli,
Yes.
and then talks to Courtney.
Yes.
But the first person he talks to is, I think, some member of the hotel security staff, correct?
Yes.
And when he approaches that individual gives him kind of a summary of what they have, so to speak, correct?
Yes.
And what he says is security got called, right?
Yes.
Who called security?
I can't remember.
Well, was it Courtney or was it Christian?
Honestly, I can't remember.
Okay. If I told you it was Courtney, would you believe me?
Same objection.
So you don't recall?
I don't.
Well, we'll play it for you, or not for you. We'll play it later.
Okay.
So do you recall that person telling you that his security people came into the hotel room and noticed clumps of Courtney's hair on the floor?
Yes.
Now, as a trained investigator, clumps of hair on the floor, would that indicate some kind of physical struggle to you?
Objection. Speculation.
You can answer the question.
Yes.
Now, in that interview, Courtney admits she threw a glass at Christian, right?
Yes.
The glass didn't hit him, did it?
I'm not sure.
Also in that video, Courtney tells the officer right before she's being arrested that she didn't tell him the whole story, right?
Yes.
Because she didn't want Christian to get in trouble, right?
Yes.
So you testified as to the medical examiner. I think you indicated that in your interactions with him and reading his report, the manner of death was a homicide, right?
Yes.
By a single stab wound, right to the subclavian artery, correct?
Yes.
Now, in your training experience, even a homicide, right, can be justified, right?
Yes.
And initially, you didn't make any arrests because you were looking at this as self-defense, correct?
Objection.
Yes.
Now, you talked about blood spatter and
Droplets?
droplets and pooling of blood, right? But you're not a blood spatter expert, correct?
No.
You were just recanting what's on the scene that you saw, right?
Yes.
And that the blood, as far as you're concerned, was consistent with somebody sustaining an injury and then walking around the apartment or running around the apartment, right? You don't have to look at the state. You can look at me when you answer the questions.
Okay.
He's asking the questions, they will object, if they have an objection, I will move the words.
Objection. Settle. 702, states direct. I mean,
So is the blood that you saw at the scene, I'm not asking you for an expert opinion, but it's consistent with somebody walking or running around the apartment after sustaining an injury, correct?
Yes.
Now, do you know, again, you weren't there when the injury occurred, right?
Correct.
You also mentioned in the Las Vegas video body cam, I think that Courtney said, oh yeah, I threw a plate at him or something, some other stuff. Is that correct?
Yes.
Okay. Are you Hispanic?
Yes.
Okay. Do you have an abuela?
objection.
Do you have a grandmother? I'll move on. Do you know what a chancleta is, detective?
Judge, objection.
I'll move on, Judge. I'm sorry. Now you also said you pulled Ms. Clenney's entire criminal history, correct?
Yes.
And you said it was a California case? It was
Yes.
a DWI or DUI?
I think they call it DWI over there.
Right. And that was a case that the charges were dropped, right?
Right now I can't remember.
And the incident in Las Vegas, where she was arrested for battery, right? That case was also dropped, correct?
Yes.
You also testified that you did a cell phone extraction of Mr. Obumseli's phone, correct?
Yes.
And you were capable to do that because Ms. Clenney gave you the passcode for that phone, right?
Yes.
She was cooperative with you during your investigation, correct?
Yes.
And in fact, I offered to be cooperative with you throughout the course of your investigation, correct?
Yes.
I'd call you every now and then just to follow up, right?
Yes.
Or I would text you, right?
Yes.
And I even said, hey, look, if something changes in your investigation, let me know and we'll go to your office, surrender, right?
Yes.
Detective, you, in extracting that cell phone, you testified on direct about text messages, specifically text messages that took place on October 9th and 10th, I believe it was. Do you recall those text messages?
Yes.
And I believe those, basically, in summary, you said that those text messages indicate that there was a physical altercation and Courtney hit him in the head with a phone, correct?
Yes.
There was a physical struggle, correct?
Yes.
Do you know what happened that caused Ms. Clenney to take that drastic action?
May I review my notes real quick?
Sure.
No, I don't remember right now.
Okay. And I think it was, again, this is State's Exhibit 4, is the text messages from October 9th, where he mentions that I think Christian says, oh, and stabbed me in my leg or something to that effect,
Yes.
right? In the follow-up text messages by Courtney responding to that, she never admits to stabbing him in the leg, correct?
I would have to go back to the messages for that section.
You don't remember?
No, not right now.
I mean, that would be something important, right? That you would have noted if
Yes.
she would make an admission of stabbing him previously, correct?
Yes.
Did you know that Christian would harm himself sometimes by cutting himself?
No.
You didn't know that? In your interview of Courtney, did she not disclose that to you?
Objection. Still not relevant. And the court has to go before.
Can you say it again?
Did Miss Clenney, during the course of your interview with her, tell you that Christian would cut himself?
I remember that she said that he tried to hurt himself at one point, but I don't remember to what extent.
Okay. Now, the text messages on State's Exhibit 4, which I have up on the screen, do you remember this text message, which came hours later after Christian describes being hit with a phone? Do you remember Courtney's response at, looks like 4:34 a.m., whatever time that was? I think this is in Las Vegas. Do you remember, if you decide to get, this is Courtney, if you decide to get security, call, I will let them know exactly what happened.
What's the question?
Do you
Well,
recall
if I
this?
remember that, yeah.
So is it fair to say that these texts don't say exactly what happened?
No.
And it appears to me Courtney's not afraid of telling somebody exactly what happened, right? That's her text?
Correct.
Now, you also have text messages from January 30th, which you went through with the state that talk about where he actually goes to the hospital and receives stitches, right?
Yes.
And he's cut across, his chin and I think he said his cheek, correct?
Yes.
Now, I think that was an argument over some text messages, right?
Yes.
Again, we don't know what happened in phone calls, perhaps, prior to the text messages.
No.
We don't know what conversations they may have had, correct?
No.
All we have is these texts, right?
Yes.
Again, this is where the state indicated that she said, oh, I hope you enjoy the hospital, something to that effect. I just hope you have time to cool down or think about your actions, right?
Oh, I don't know about cool down, but
Well, hopefully, again, Courtney's text, hopefully this will give you time to think about your actions, right?
yes.
I'm sorry, cool down, those were my words. I all right? Enjoy the hospital. Right? You don't know what prompted her prior to these texts to send these, do you?
I mean, enjoy the hospital. Nobody wants to enjoy the hospital.
Right, but you don't know what occurred, right?
No.
Okay. Now, again, in the follow-up message, right? Courtney tells Christian, tell them your side, then I'll tell, sorry, I'm getting older. Tell them your side, then I'll tell them what happened. Right? She texts that.
Yes.
Is somebody who's afraid of the truth coming out, would they send a text like that?
Objection, speculation.
I'll move on. And his answer is that I'm not saying anything.
Yes.
Right? I mean, people could not want to say anything for a bunch of reasons,
Objection,
right?
counsel testify.
One of which could be that Christian doesn't want the truth to come out, correct?
Objection, speculation, counsel testify.
Then I think her next test is an LMAO, right? And then followed by you should, meaning she's asking him to tell whoever what happened, right?
Objection, speculation, best evidence, counsel testify.
Can you repeat it?
I'm saying after the LMAO, her text says you should, meaning you should tell somebody what happened, right?
Yes.
I mean, that's the logical reading of this, right? I'm not making this up.
Objection, counsel testifying. I just want to ask for the counsel to stick to the ground.
Did you, I think you indicated that the photograph of his stitches pinged, that the GPS data associated with that picture put him at Mount Sinai Hospital?
Yes.
In that area, right?
One of the injuries points at Mount Sinai Hospital.
Okay. Did you pull the medical record? Did you serve a subpoena for the medical records from Mount Sinai Hospital?
I did not.
Do you know if the state executed a subpoena for those medical records?
I don't know.
Do we know for a fact that that's where he was treated at Mount Sinai?
I mean, it pings right on top of Mount Sinai, so, and he was in the bed, and the picture shows that he's in a medical bed.
Right. I mean, I'm just trying to figure it out.
There's no other hospital there.
It could be an urgent care maybe in that area. Now, you mentioned in those photos that Christian has raccoon eyes.
Yes.
And what is that to you? Dark circles in his eyes?
Yes.
Doesn't necessarily mean he was punched in the eye, does it?
Well, compared to
Objection, speculation.
well, yeah, already has a laceration to the bottom of the lip and injuries to his face, so it's consistent with getting hit multiple times and also slashed in the face.
All right, detective, you can't say one way or the other whether those dark circles are from a physical contact or maybe he hadn't slept for a long time, right?
Definitely not that he hasn't slept in a long time. They're definitely injuries.
Do you know that Christian and Courtney were up at all times of the night? I mean, they were living kind of a party lifestyle, wouldn't you agree?
Objection.
There was drugs involved, correct?
Yes.
There's some text messages talk about Christian using cocaine with Courtney.
Yes.
Detective is part of crime scene responding to the apartment where this incident occurred. They also photographed certain items that had some type of evidentiary value, correct?
Yes.
And part of what they photographed were letters written from Christian to Courtney, correct?
Yes,
And in your assessment of those letters, would you say that those letters are an acknowledgement of his abuse of Courtney?
I can't remember.
Speculation, best evidence.
Did you see those photos?
I did.
Did you read them? Well,
I
did you
did.
read the wording contained in those photos?
I read them.
Okay. If you look up on the screen, Defendant's Exhibit E, looks like this letter was torn up at some point. Is this what I'm talking about, the photographs of the letters?
Yes.
And there's highlighted sections in there, correct?
Several objections from the overseer.
You on OT?
Yep.
This your day? No, that's your Thursday. So, since you stayed.
All right, just Recapping, so there were some letters that were photographed and retained as evidence by your department, correct?
Yes.
And as the lead investigator, lead homicide investigator in this case, I'm sure you reviewed that evidence, correct?
Yes.
And do you recall these letters?
Yes.
Okay. And so Defense Exhibit E is what the government provided to us, that you seized, the department seized. And part of the letters, although it's writ, says that he's guilty of gaslighting her, right, and mentally abusing her, right? Those are the words contained in this document?
I can't remember, so I don't feel comfortable answering that.
Okay, that's fair enough. Were you able to determine that these letters were written by Obumseli to Courtney?
Again, I can't remember. I read them that one time, and then that was months ago.
I'll move on. The court has these. The witness indicated he has no memory, so I'll move on, Judge. I apologize. Now, you testified as well as to some recordings that were made by Obumseli, where Courtney can be heard screaming, right?
Yes.
And it's actually, we've mentioned it as video, but it's a video file, but it's actually just audio, correct?
No, I think
Except for one that's in the lobby.
I think they're all video.
Well, they're video files, but there's actually no video because the phone is secreted on.
Well, if you watch carefully, at one point he does take out the phone, and then you can see the defendant on the floor screaming.
Okay, the point of it is, the bulk of it is just audio, right?
Okay, yes.
Okay. Now, the person who recorded that is who?
The victim.
Mr. Obumseli, right?
Yes.
He knows he's being recorded, right?
Yes.
If you know you're being recorded, you're going to say kind of, what you want to say, right?
Objection, calls for speculation.
That person has an advantage to know they're being recorded, correct?
Yes.
You don't know what happened before that recording took place.
No.
You don't know what happened after that recording took place.
No.
And that's true for the several recordings that are part of the evidence in this case, right?
Yes.
As part of the documentation that you pulled from the One Paraiso this management company, you said you were provided incident reports, correct?
Say that again?
The One Paraiso subpoena returned a bunch of incident reports, correct?
Yes.
And you said there was like a lot of them, right?
Yes.
Those are not your words, those are mine, but there was a lot, right?
Yes.
Too many, I think you said.
Too many.
Right? Which shows a history of some kind of domestic issues going on, correct?
Yes.
And one of those, again, was the body-worn camera from April 1st, 2022, correct?
Yes.
Where Courtney asked for a restraining order, correct?
Yes.
And in that same video, right, one of the officers asks her if he's been violent with her in the past, correct?
I can't remember.
Okay, we'll move on. It's been admitted as an exhibit to the portrait. Now, you mentioned something about Christian's fob was 01027 and Courtney's fob was 01058. Is that correct?
Yes.
And at some point, clearly, I think you testified that her fob became inactive in March of 2022, correct?
Yes.
Okay. You don't know when she lost that fob, do you?
No.
Now, the day of the elevator video, you don't know if she had her fob on her, correct?
Correct.
She might have left it upstairs, correct?
Yes.
Now, you mentioned you served subpoenas on Courtney's for her financial records on some banks, is that correct?
Yes.
Now, I think you testified it was $2 million.
Yeah, just
Is it
over 2 million.
it's over 2 million? It's not over 1.3 million?
No, I remember the total between both wire transfers. It equaled over 2 million.
You sure?
I believe so. Yes.
Do you want to review anything before you say that that's your final answer?
No.
Now, the state talks about your efforts to locate Miss Clenney,
Yes.
right? You remember testifying about those efforts,
Yes.
right? You actually traveled to Hawaii, right? When you found out she was there?
Yes.
So you got a free trip to Hawaii.
Yes.
Paid for, the city of Miami paid for that, right?
Yes.
Judge,
So, before you decided to fly to Hawaii to effectuate the arrest of Ms. Clenney, did you lose your phone?
No.
So you had my contact information, correct?
Yes.
You never called me and said, hey, Frank, you know, look, things have, changed and we want to surrender Ms. Clenney, right?
objection relevant.
Say that again.
You never called me and said, hey, listen, things have changed. Bring in your client.
No.
No? Instead, you enlisted the U.S. Marshals to go get Courtney out of Hilo, Hawaii. And do you know where she was in Hilo, Hawaii?
She was in a rehab facility.
In a medical rehabilitation facility, right?
Objection, testify.
She didn't flee to Hawaii, correct?
Objection. You know what, I will withdraw.
Yes. I mean, what was the question? Sorry.
Did you think she fled to Hawaii?
No.
She was there to get help, right?
Yes.
Did you speak with her
Yes.
when you were in Hawaii?
Yes.
Did you tell her that you thought your investigation was closed? You're under oath today.
If I thought that she was under,
Did you tell her that this case had been closed by you?
that I was closed?
Yes, sir.
No.
And again, just talking about the phase 2 issues, you recall me staying in contact with you, maybe every couple of weeks or 3 weeks to a month, I would contact you, correct?
Yes.
Judge,
Now, talk,
more counsel needs to ask a question and get an answer.
now, in reviewing the financial records, right, you're just reviewing the documents, correct?
Yes.
Do you know why she transferred those monies into her father's account?
No.
Do you know how much she currently has in her accounts?
Right now, no.
Yes.
Right now, no.
At the when you got the subpoena returned, when was that?
I can't remember the exact date.
And what was the balance in her accounts?
I believe it was about $4,000.
Should have no further questions. Thank you, Detective.
Yes, sir. One very brief matter for the side. it pleases the court, as discussed sidebar, the state provided the clerk in the exhibit to just attach, which will include exhibit 33, which is an Instagram live video. Detective, I want to pick up a little bit where Mr. Prieto left off, and he discussed with you about not contacting him when a decision to arrest was made. When was your arrest warrant signed, if you remember?
I don't remember the exact date.
With the warrant refresh recollection?
Yes,
Okay, do you have a copy of it?
I do.
Give me 1 second. Do you have a copy of the warrant? Oh, you don't. Oh, thank you. Detective, I'm giving you the last page of the warrant. When was that warrant signed?
August 4th,
Okay.
2022.
You remember when the defendant was arrested?
Yeah, yeah, it was like a week later.
Okay. This warrant was obtained under seal. Do you recall that?
Yes.
Okay. Do you recall why it was obtained under seal?
So no hints would be given to the defendant, and then they would flee again,
Was
or
you-
flee anywhere else.
Okay, so you said flee again, or anywhere else.
Yes.
So I want to parse that out because Mr. Prieto asked you the question. Mr. Prieto, on cross-examination, asked you the question, did you believe the defendant fled to Hawaii? Your initial answer was yes. He then asked you again in a different way. You said no, and then he asked you about rehab. So I want to redirect you as to that conversation. Okay. In the context of the defendant being in a rehab facility, you don't have any reason to doubt that she was there for some kind of help.
Correct.
Okay. Do you agree that it's simultaneously true that she could have fled there?
Possibly, yes.
Okay. Was that a concern and why you did not contact Mr. Prieto?
Yes.
You've been in homicide and robbery
Yes.
units. You agree that those units are highly investigated?
Yes.
In the context of those investigative units, does the city of Miami do everything by themselves, or do they rely on the prosecutor's office?
We rely on prosecutors as well.
And that's true for review of search warrants, subpoenas, and particularly arrest warrants.
Yes.
Okay. So let's walk through that. In the nature of a homicide investigation, how many have you participated where there have been arrests?
Currently,
I'm talking about participated, so if you
No.
assisted as robbery or anything else.
oh, in robbery too?
Yeah, all homicide
Oh.
investigations that you've ever assisted on, how many have been
On
arrested?
homicide alone, about 6. That have 6 or 7 that have been about 8 with that have made an arrest, and then in robbery, probably over 100.
And how many of those has the defendant asked to surrender themselves? It's redirect. It's redirect.
None.
None. Is a homicide a dangerous crime?
Yes.
In dangerous crimes, how do police approach the apprehension of a subject in that case?
As safe as possible,
Why is that?
because a lot of the times they know that they're going to spend the rest of their life in jail, so they'll take any action to not go to jail.
Mr. Prieto discussed with you regarding quote unquote cooperating with the investigation. Do you recall that?
Yes.
In this case, you mentioned that you obtained cell phones and did search warrants on those.
Yes.
For Ms. Clenney, how many phones did you obtain?
2.
Okay, how many warrants did you execute?
2.
At any point in time, was the defense counsel contacted about the password to search those devices?
No.
They were not? At no point in time, the defense has offered to or was contacted?
No.
In September of this year, the defense was not contacted for the Did the defense ever provide a pen for the phone?
No.
Have you been able to enter her phone?
No.
What efforts have been expended in attempting to enter her phone?
We have taken the phone to the Secret Service, and they have attempted to do what is called a brute force to be able to get into the phone.
With regards to the cases that the defendant has, one of which was the Las Vegas case, Mr. Pareto asked you about the posture of that case, and more specifically, whether it's been dropped or prosecuted or else. Do you remember that?
Yes.
Okay. The Las Vegas case, you said was dropped.
Yes.
The victim in that case and the sole witness was the victim in this case?
Yes.
And that's now a deceased person?
Yes.
In the context of that letter, which you saw and the one time you reviewed it, was there any documentation of physical abuse by?
I'm sorry. Can you repeat that one more time?
Sure. In the letter that the defense showed on the screen,
Yes.
that was torn in the middle, missing a chunk. Do you know what Christian Obumseli's writing looks like?
No.
Do you know if that was him that wrote that letter?
No.
It was certainly signed by a Christian Obumseli.
I can't remember if it was signed or not, but.
So you don't know if he wrote it?
I don't.
You don't know if the defendant wrote it?
No.
You don't know the context of that letter?
That I remember, no.
That letter itself did not document any incidents of physical abuse.
I don't remember.
Let's talk about some of the messages that Mr. Pareto discussed with you. He mentioned the October 9th, 10th, and 11th sequence of messages. And specifically, he showed the screen message where it says, "Tell them exactly what happened." Do you remember that?
Yes.
Was that a threat?
Objection calls for speculation.
In what context was that message given?
Objection calls for speculation.
The message, "Tell them exactly what happened." What occurred immediately before that message and immediately after that message?
I would have to see the messages. I can't really remember right now off the top of my head.
Sure, I'll just direct it for it. The January 30th messages Mr. Pareto put on screen, the first message was said something to the effect about, "This will give you time to think about your actions." And then a second message shortly after it said, "Enjoy the hospital."
Yes.
That was the first message. "Think about your actions" was the first message after that time break you were talking about earlier?
Yes.
Okay. So there was the argument that was documented over the overtime of the football game.
Yes.
There was a break in time. I'm not trying to offer anything, so tell me if I'm wrong here. I'm just trying to understand your testimony. There was the argument, time break, and then the first message was, "Tell them, think about your actions and enjoy the hospital."
Yes.
Okay. The defendant, like Mr. Pareto showed on screen, wrote LMAO. What does LMAO mean?
Laughing my ass off.
Okay, so the defendant was mocking the victim.
Objection calls for speculation.
Did you read all of those messages, like beginning to end and all of them?
I did.
Okay, so in the context of processing those messages in those contexts,
Yes.
is the defendant mocking the victim?
Objection calls for speculation.
You can opine.
Yes.
Mr. Pareto asked you about your ability to identify victims of domestic violence. So I want to talk about that. Victims of domestic violence, do they often cover for their abusers?
Yes.
Mr. Pareto even asked you about the Las Vegas incident where Ms. Clenney at the end said, "Well, I didn't tell you everything." Right?
Yes.
Okay. So is it uncommon for a victim of an aggravated battery to not tell the hospital what caused it?
Objection.
Redirecting. When you saw the body camera of the Las Vegas incident, the officer, before kind of really anything, went straight to Mr. Obumseli and read him his Miranda rights, right?
Yes.
Okay. Is it uncommon for males to be perceived as the aggressor in domestic violence incidents?
It's not uncommon.
As a police officer yourself, is that often who you perceive to be the subject or the culpable party?
Yes.
Okay. Was that the case here?
Yes.
Such as in Las Vegas, where there was further investigation revealed the defendant was the aggressor. Is that what happened here?
Yes.
And let's talk about how you got there. The arrest warrant. You said you've worked on 8 homicide cases. How many have been arrests in homicide cases? How many of those arrests were yours?
7 of them.
Okay. And on those, how many did you apply for arrest warrants?
Maybe 6 of those.
In those contexts, is the state heavily involved in the writing of the arrest warrant?
Say that again?
Is the state heavily involved in the writing of an arrest warrant?
Yes.
Initially, for example, you perceived this to be a justifiable use of force before you got everything else.
Yes.
As part of your initial perception, is that the final call in that prosecution?
No.
Okay. What happens in a homicide investigation where you pursue an arrest warrant?
I have to sit with the state attorney's office and we have to go through everything that has been found in the case to come to a conclusion.
Are you directed by the state to pursue investigative steps?
Yes.
As part of being directed by the state attorney's office to pursue investigative steps, does that include subpoenas?
Yes.
Can you write a subpoena?
No.
Can you issue a subpoena?
No.
Who do you need to issue a subpoena?
I need the state attorney's office.
Let's talk about Ms. Clenney's, the defendant's statement to you. Mr. Prieto asked you, and essentially she outlined 3 iterations of the incident. Do you recall that?
Yes.
Okay. And he tried to focus in on the part of the warrant where it said that there was inconsistencies throughout. So I want to go through that. The defendant gives, iteration 1, 2, and 3.
Yes.
In iteration, for example, 2, did she give more or less details than in iteration 1?
On 2, she gave more.
Okay. So even though she told you a story for statement 1, she told you a bigger, more sensational story, statement 2.
Objection, Judge.
I'm just,
Counsel's testifying based on that.
was the second statement, because you said it was more details, was it more or less sensational than statement 1?
More.
Okay. So in that context, is her statement 1 consistent with her statement 2?
No.
Okay. Why not?
Because she's adding more to the story.
Okay. Why does it matter that she's adding more to the story?
Because it helps us come to a better conclusion of what actually did occur, and it's filling in the gaps of the story.
And then statement 3 was that last recap where she takes a moment and talks to herself, right?
Yes.
So let's process through that. That one, that third statement, was she speaking faster or slower than her 2 prior statements?
I can't remember.
Okay. Was she kind of rushing through it, or, I mean, what I'm trying to figure out is, did she give more details on statement 3 than statement 2?
I want to say she was rushing through it because she was, I guess, getting annoyed that I kept asking her for the story again and again.
Why did you keep asking her for the story over and over again?
Because sometimes the more that we ask the story again, something clicks to mind and they remember a new detail.
And so you weren't essentially trying to trip her up, you were just trying to get
More
trigger
information.
Okay. That third iteration, was it the same as 1 and 2?
I can't really remember too well.
I guess my point is, in every iteration, she told the story that she was grabbed by the neck, pushed against the wall, and then down, got up, got a knife, and stabbed Christian.
Yes.
Or threw a knife at Christian.
Yes.
But each one of the 3 accounts were different.
Yes.
How we got there, I guess, is different.
Yeah.
The manner in which the defendant described in her statement being grabbed at the neck, forced against the wall, thrust to the ground, as Mr. Prieto was testifying. Did you see any injuries on her that would corroborate any of it?
No.
We talked about the Instagram video ourselves, and Mr. Prieto showed a abrasion on her right shoulder, almost by the bra strap, and press like a circle on her wrists and her arms.
Yes.
In reviewing the Instagram video, did you see those bruises?
Yes.
So they predated the stabbing?
Yes.
There were these neighbors that Mr. Prieto discussed, and they provided the statement that you interviewed. One talked about running around a car, and one talked about an incident at a dog park. Do you recall speaking with Mr. Prieto about those?
Yes.
So let's talk about it. The person that's talked about running around the car, did that person tell you they saw what led to and what happened after that incident?
No.
Did that person understand the context at all, or tell you what the context at all was of that?
He assumed that he was trying to pull it out of the car.
Okay, but he didn't tell you beginning, middle, end.
No.
Dog park incident. That individual, did he tell you beginning, middle, end in the context of the incident?
No.
So I ask you those questions in the lead up to the surveillance video from February 21st. An individual that would see part of that video, that would be an individual who would say Christian is striking Courtney.
Yes.
Without seeing the defendant walk into the elevator, holding the door, and then attacking him beforehand, they are lacking context?
Yes.
As part of the search of the apartment, documents with the victim's names were obtained. And I'm bringing that up in the context of Mr. Prieto talking about the lease and who's on the lease. Are you aware that Mr. Obumseli is listed as a permitted occupant of that apartment? I'm asking if he's aware that that is. You can answer.
Yes.
Okay. Is he a permitted person to enter?
Would I be able to look at the?
Yeah, you can look at your, if you have to. You guys remember refresh?
Yes.
Was he a permitted person in that apartment?
Christian Obumseli.
Was he?
Yes.
Okay. As part of the documents obtained as part of the crime scene documents in the scene, at any point in time did Miami Police locate an electric bill?
Sorry, say that one more
At
time.
any point in time did City of Miami locate an electric bill in the name of Christian Obumseli?
I can't remember.
Okay. If it did, it would be in the crime scene photos?
Yes.
Okay. When you went through, did you locate clothing belonging to a male?
Yes.
Did you locate his belongings?
Yes.
Mr. Prieto was discussing with you the defendant having quote unquote kicked him out. As a fellow tenant of that unit, would she have been legally?
Objection, Judge, calls for legal conclusion.
Did she let him back in April 1st?
Yes.
Did she let him back in April 2nd?
Yes.
Did she let him back in April 3rd?
Yes.
Mr. Prieto asked about or discussed with you body worn camera from an April 1st incident. So I want to talk to you about that. Have you reviewed that body camera?
I did, but I don't remember too much from it.
That's fair. Do you recall a conversation about who was training you?
Yes.
Okay. Do you recall the defendant making a statement that she needed to get a restraining order before the victim got it?
I remember the restraining order part, but that's it.
Okay, I'll just direct the court to that. Do you recall a police officer asking the defendant whether she was under the influence of alcohol or controlled substances?
I don't remember.
Okay, I'll direct the court to that. Do you recall whether the police instructed her as to the circumstances in which of how to obtain a restraining order?
Yes.
And did the defendant state anything that would have justified the issuance of a restraining order?
I'm sorry, I didn't hear you.
Did the defendant say anything that would have justified the restraining order?
I don't remember.
Objection, Judge. Calls for legal conclusion.
Mr. Prater discussed with you regarding clumps of hair in the Las Vegas incident. So I want to walk through that with you. Do you know whether that was human hair or extensions?
I don't.
Do you know whether the defendant took them off herself or whether they were ripped off?
I don't.
Did, in the video, did the defendant's hair appear to be disheveled?
Yes.
Okay. Did it appear to be yanked, like missing patches?
No.
So you don't know how the quote unquote hair, clumps of hair got anywhere?
I don't.
Mr. Prater discussed with you about blood at the apartment and specifically said the words that the droplets of blood was consistent with running around the apartment. Do you recall that?
Yes.
Okay. So since Mr. Prater asked that, I'm going to redirect you as to that conversation. We discussed ourselves 1, 2, and 3 bloods. 2 were clumps. 1 was where the 2 guest bedrooms interlocked.
Yes.
And the defendant was found cradling the victim. The second was a little bit further into that.
Yes.
Right. Okay. So then the droplets of blood, where was that?
It led from the second pool of blood to the master bedroom and bathroom.
Okay. Through the kitchen.
Yes.
Okay. So because that pool of blood that we discussed was number 2, where the defendant was found, or the defendant and the victim were found, that was the conclusion of the droplet. Was that the conclusion of the droplet trail?
I'm sorry, can you start over?
Since we know that the victim and defendant were found at that second pool that we discussed.
Yes.
Is your testimony that the droplets, because it was running around the apartment, that was the conclusion of the droplets of blood throughout the apartment?
Yes.
And more specifically, the droplets of blood begin in the kitchen, go to the master bedroom, back through to that second pool?
Yes.
As it pertains to the calls, Mr. Prieto brought up how the defendant called 911. Do you remember that?
How, on which one?
How the defendant called 911 when Christian was stabbed?
Yes.
Okay. So, and we know that Mrs. Clenney, the defendant's mother, was on the phone with the defendant at the time of the stabbing, specifically the first call.
Yes.
Mr. Prieto made a very long conversation about how you didn't ask about the second call.
Objection, Judge.
But we'll get to that. So as it pertains to the stabbing that's having occurred during the first call, that first call was for 6 minutes at 2:43. Is that right?
Yes.
Okay. So Mr. Obumseli was stabbed somewhere between 2:43 and 2:49.
Yes.
The defendant's first call after the stabbing, do you recall who it was to?
To her mother. Her mother.
How long was that call?
I believe it was about 7 minutes.
Okay. And then after those 7 minutes passed, did she call 911 or did she call someone else before?
I can't remember.
Okay. I'll direct the court to the records. And then she called 911.
Yes.
So in a nutshell, she waited 10 minutes before she called 911.
Yes.
Objection, Judge. It's facts, not in evidence.
I'm eliciting the fact to be in evidence. So let's discuss your conversation with Mrs. Clenney, and the court has the audio recording of it. But I want to kind of reverse do it. When we talked earlier, I asked you whether you knew anyone else was listening on the call, and you told me no.
Correct.
Did you find out whether someone else was listening on that call?
Yes.
Okay, who was that person?
Her father.
Okay. When the father interjected earlier, you said that the father interjected to say that Mr. Pareto was at the police station.
Yes.
Okay. That was essentially the first time where you became aware of the lawyer and everything else.
Yes.
Because this is, object, this is outside the scope. of my cross.
It's literally redirect. So at that point, when you got up and left to go let Mr. Pareto into the police department, that ceased your interview with Mrs. Clenney.
Yes.
When you interview witnesses, do you interview them together or separately?
Separately.
Why do you do that?
So they don't share information with each other, and we can get two different understandings of their side of the story.
So not having known that Mr. Clenney was on the other line of that phone, you don't know whether he was feeding her answers or not.
Correct.
Separate from that, now knowing that Mr. Clenney was listening in on the conversation, did you have any reason to further elicit any testimony from Mrs. Clenney?
No.
Now, let's talk about the two calls. Did you ask explicitly about the first call?
Yes.
Okay. Did Ms. Clenney answer your questions?
Yes.
Okay. At any point, did she go on a tangent?
Objection on relevance.
Sure. While talking about the incident that happened April 3rd, at any point in time, did she stop talking about the April 3rd incident and start talking about the week prior?
Yes.
Okay. At any point in time after talking about how terrible the victim was, did she ever return to the date of incident?
No.
Okay. So Ms. Clenney not only didn't discuss the second call, but then she redirected
Yes.
to a separate incident. Okay. Can the defense put on the text messages? The text messages that you showed from Mrs. Clenney? Can you put them on? Yeah, do it. Come on, let me do that. So Defense Exhibit C, the screenshot of the text messages, right?
Yes.
And Mr. Graves will discuss with you how 404 is just because they were screenshot at Central Time and so on and so forth. So what time was police called?
I don't remember that time right now.
Would you agree it was before 5?
Yeah.
Okay. So all of these text messages were sent after stabbing?
Well, I can't really tell.
Well, the first message 4:04 p.m.
Yeah.
Do you have an iPhone?
Yes.
Okay, so do the messages kind of load reverse chronologically?
Yeah. Yeah.
Okay, so you agree that these messages were sent after the stabbing?
Yes.
You've reviewed the body camera in the case, yes?
Yes.
When the officer that first arrives and renders aid, what does he do to Ms. Clenney?
He separates her from the victim.
Is she put in custody?
She's detained.
Yeah. Does she handcuff the victim?
Yes.
Okay, so did she have access to her device?
No.
Okay. So when Mrs. Clenney sends this message, please tell me what is happening, asking the defendant what is happening, the defendant would be unable to reply.
Correct.
So Mrs. Clenney, not knowing what happened and demanding that the defendant call her, then said, even though it was self-defense, don't say anything with the police without getting a lawyer first. That's what's in Defense Exhibit G.
Yes.
But that wasn't the message that you saw, right?
No.
The message you saw was the last one?
Yes.
The last message says, before it cuts off your bottom, it is very important, ... Even though it was self-defense, you cannot say anything without an attorney exclamation point. Innocent people get in trouble all the time, right?
Yes.
Is that offering the defendant self-defense?
Objection, Judge, speculation.
So I want to talk to you about why you didn't talk to Mrs. Clenney and Mr. Clenney any further. After your investigation, et cetera, then you briefed the state, and that's where we were at. At some point, did you realize that Mrs. Clenney's statement was kind of inconsistent with everything we talked about?
Yes.
Would her further statement have contributed anything either positively or negatively in your investigation?
No.
Okay, why not?
Because she might want to make up any more excuses or change something she says.
I'm asking because defense counsel crossed on the issue, and I'm asking him why he didn't do something in the investigation. So if counsel's going to make the lack of evidence argument, I can move that. Why didn't you interview Mrs. Clenney?
Because I didn't know if they were going to try and make up a new story or change anything from that date of incident.
What about Mr. Clenney? Is that the same answer, I suppose?
Yeah, pretty much. Okay.
Why not Mr. Clenney?
About the same answer.
Neither, on cross, Mr. Prieto asked you about where Mrs. Clenney and Mr. Clenney were in relation to the defendant. And if I recall correctly, you said that they were in Texas and she was here.
Yes.
Were they witnesses to this incident?
No.
So they do not know what happened inside the apartment.
Correct.
No further questions.
Yes. I'm not going to recross it.
I actually have one question that I would want you to go back to, and there's a lot of calls. Can you go back again to the timing of the 911 phone call as it relates to the phone calls that the defendant was making? I'm just still a little bit confused about that. You said that's not evidence. I have a follow-up. So let me just make sure that I'm putting it all together correctly. So.
Sure. 1 second. Detective, I'm going to ask you to step down. Just to get through the screen.
And then if you have questions, I'll listen.
Yes.
Does the court want me to go straight to the exhibit, or does my PowerPoint slide? I'll go straight to the exhibit. Can I borrow the pencil?
Which one?
The one in the box. Detective, I'm showing you what's in evidence as stated to the 16.
It's exhibit 1.
well, sorry, exhibit 1 on the flash drive, exhibit 16, thank you, within the flash drive. Do you know what all of these columns mean? Okay, can you tell the court what these columns mean?
This is that's called, the phone call changed from, this is the date and time of when it was made.
Okay, and this is not suicide time?
Correct.
What time is that?
It's ETC.
In April, how many hours ahead of time is that?
4.
You mean ahead, so that it's 0 or not? Minus.
Yes.
Okay, so this first column, 4/3/2022, 146, that actually, if I'm understanding correctly, April 2nd, 2022, 9:46. So I want to direct you to the one that sticks out here is 911. Do you see that? Okay, so that's the first 911 is 16, it's the 17th and 18th slide on the column 0. Do you see that?
Yes.
Okay. What time is the 911 for?
2057, which would put it back to 457.
With 1657.
Yeah, 1657.
Okay. So immediately before that, the defendant dialed this number 76-472-8232. And that was an 18-second call.
Yes.
Do you know who that was with?
I do.
Okay. Do you know if that was one part recently?
It could be.
Right before that, there is 2 separate calls. You see here, one is 437 and one is 393. And then the defendant's number called 512-417-3408. Who was that? That number called?
That is the
Okay. So, again, 2 calls, one is 393, one is 430. Let's talk about the first one. The first one was at 20:43. What time is that night? Okay, which is what?
It's 443.
Okay. So then there was 6 minutes, and then the next call was again to the defendant's mother for 430.
Yes.
Okay. As an aside, did you have multiple calls on that call?
Yes.
So would that explain why there's kind of extra calls overlapping?
Yes.
Right before these 2 calls, there are 1, 2, 3, 4. There, 1, 2, 3, 4. Yeah, 4 calls from 512-745-3582 to 214-789-9531. Do you see that?
Yes.
Okay. Whose number is 214-789-9531? Okay. And then, so let's go from oldest to youngest. The first call in that chain is 1955. What time is that local time? B13? No, sorry. Okay. So 1555 is what time? Okay. So 1555 is 355 local time. Is that the same time when Mr. Obumseli getting the elevator? So the defendant is calling the victim, and he's not answering. The defendant does that one more time, exact same minute. Do you agree? Okay. And then again, 6 minutes later. Okay. And then finally at 20:33, he does get another call. This one's in. How do you tell that this one's in? And then 5 or 3 each. Okay. Just for the record, sorry, I keep interrupting you. What does it mean?
It means call police for
So, just I guess put a pin in it and how much time passed between the first call to mom and the defendant call to him? So 2043 to 2057. I think math isn't our best option. Would that be 14 minutes?
14 minutes.
Okay. I don't know if the court wanted me to inquire any more about that. Worried about all. You need better stuff.
Okay. And so, going back, so the 911 call, and just kind of, without converting the time, I'm gonna use the time here, it's a little easier, because math is not your strong suit or mine, okay? It says 2057, there was a call from 911, right? And right before that, there was a call to the 512-745-3582, correct?
Yes.
This column here is the number called, correct?
Yes.
And what is this column here, the CPN?
I can't remember right now.
Well, let me just phrase it this way. There's two calls prior to the call to 911 to 512-745-3582. Is that correct?
Yeah.
So those are calls to this claim's mother, right?
Yes.
You have no idea when Mr. Obumseli received that statement, correct?
No.
Prior to the call to 911.
Correct.
You don't know if it was during the first phone call or the second phone call, do you?
Correct.
So that's complete speculation then, for you to say that there was a time lapse of 14 minutes before she called 911, correct?
I don't think so.
Well, let me ask you this. The stabbing could have occurred exactly at 2057, according to these phone records, correct? Right before the 911 call, that's when the stabbing could have occurred, correct?
It could have.
You don't know either way, right? No further questions.
I do have a very brief redirection. Mr. Graves is a very skilled attorney, and he asked a bunch of questions where you said.
Objection.
No, I'm redirecting him on the very specific point. So my question to you is, you don't know obviously because you weren't there for the stabbing.
Correct.
The reason that you know that stabbing occurred on the first call is because Mrs. Clenney said she was on the first call.
Objection, Judge. It's legal.
Did Mrs. Clenney discussing the two calls, only discuss the first call?
Yes.
And in the context of the first call, she said that the stabbing had occurred at that time, specifically. So we know definitively that, according to Mrs. Clenney, the stabbing occurred between 2043 and 2049.
Yes.
So, worst case scenario is 14 minutes from 2043 to 2057. Best case scenario is 8 minutes.
Yes.
So dependent again, before calling 911, call the mother, contact the building, and then call them.
Yes.
That's all. As far as decision is
Yes.
So Judge, I did reach out to the medical examiner, I spoke to him, I also spoke to your judicial assistant. She believes that you have availability for Thursday afternoon at 2 o'clock. And Dr. Hutchins is also available for that time.
That's good for the defense judge. Oh, 1:30?
2 o'clock.
She said 2. whatever the court wants. We're available, but I think your JA said to. One o'clock, so we have plenty of time to finish. Is that okay?
Yeah, I think it's not on my calendar. Thursday?
Well, what Saturday is it?
Is it a season?
It should be, we had C last week.
Yeah, I don't think it's that bad.
No, so we should be.
I was looking at the season.
And before 12:30. Yeah.
The one that's by itself.
So the medical examiner can't be here until 2. And so, but I do know, I have no issue with taking, if the defense has witnesses out, we can do those.
Oh, Judge, based on the information elicited about financial information, I would advise the court that we would be calling Kim Clenney, just for phase 2. But we're happy to call him out of turn in order to try to accommodate the schedule, if that's okay.
That's fine.
Okay. Thank you.
So that's 17. 17, they were 1 o'clock.
Okay, y'all. So basically, they're just figuring out their time. You know, they're going to continue for a later date, being, I'm pretty sure it's going to be tomorrow. And so I guess I'll see you guys tomorrow. We will be watching the Daryl Brooks case first, as you know. And for those of you guys that don't know what's really going on in this, I'm going to make a video and kind of explain what's really going on right now so you guys will understand what's going on, because I see some people saying that they don't know too much about this case. So I will be updating you guys on that. So I will see you guys mañana. Bye-bye.